Good morning, good afternoon, good evening, depending on when and where you're watching this. And if you're replay crew, good whatever day and time it is. But for me, it is Thursday. It's April 3rd. Jury selection is well underway in the Karen Read case. We're going to be talking about that today, watching some more video of the court instructing the jurors. It's going to be somewhat similar to what we've seen before, but we will go through today's jury instructions. The last I checked, there were 7 seated jurors. The news is reporting that the judge wants to sit 16. I was thinking perhaps up to 18, but they have seated jurors much faster than I anticipated, which I think is a good thing. I'm glad they've been able to find jurors who are able to keep an open mind in this case. Remember, they're not looking for jurors who have never heard about the case. They're not going to find jurors who have never heard of it. It's jurors who are like, yeah, I've heard of it. I don't have an opinion about it. It's just like, people talk about stuff and I'm like, okay, fine. So we are going to be covering that video. There's a new lawsuit against the judge and the court system. It's not really like a personal lawsuit against the judge, but the judge is the one who did the buffer zone. So there is a lawsuit about the buffer zone. We're going to take a look about that. I think it's helpful to take a look, and I will probably ask you to do some thinking on both sides of the issue with regard to the buffer zone and ask what you guys think about it. Thank you for the compliments on the hair. We refreshed the color a little bit yesterday, and it is spicy here. So if you hear alerts going off from my phone, I apologize in advance. They will jump scare me. They might jump scare you, but also I am keeping an eye on weather here and trying to make sure we can stream in between all of the spiciness today. Hopefully all of you are safe where you are. And if you are watching this in the background while watching Ryan Holyall or your weather of choice, don't feel bad. This will be live. Watch the things that impact where you live most specifically first. Like, look, the replay crew, we're going to timestamp everything down below. If weather is a concern for you today, as it is for so many, just do that first. It's been a long night. This is the time of year where I would have never really understood without living here. Like, people tell you, but you don't quite know. It's just fantastic. You can't tell if it's allergies, if people are tired, if it's both. It's all of the things for me today. So it's like, Emily, you doing okay? We're tired. The winds are kicking up something that's making everything be a mess. So no, Brentwood Chick said, Emily, where was it? Emily, did you get enough sleep? No, I didn't. But I did. Brentwood Chick. Sorry, I did not get enough sleep, but that's okay. It's been multiple days of not enough sleep, but 'tis spring in the South, and that is one of the things. Look, here's what I will say. I appreciate having a heads up. I appreciate being able to make a plan. I appreciate being able to watch storm tracks come in. I still am deeply traumatized from being shaken out of my bed by earthquakes, including Northridge. And so when it comes to being an adult and getting to choose the weather systems that I am willing to rock with, I appreciate being able to watch storm tracks come in. And the way that weather tracking is so close, I feel like at least there's something I can do, which is much better than earthquakes where there's nothing that you can do. I feel like at least we can do our best, and then whatever happens, happens. But we can do our best. At least we can prepare, and we can keep an eye on the storms coming through, and we know. But kids don't have school today, so they got to go back to bed and sleep in. Who's the designated weather watcher in their house? I'm the designated weather watcher in my house. So if any of you are the designated weather watchers, then you know exactly what it is. Because look, this is one of my keys to life, and we're narrowing in on closer to 50 than any other age. So we're just going to share with y'all. But here's what it is. You've got to pick the things you can delegate without getting mad about. You've got to pick those things. There are things that I know if I delegate them and they're not done the way that I would do them, then I'm going to get mad. And that's not fair to anyone else. So I need to take responsibility for the things that I can't delegate and have chill about. If I can delegate it and be chill, good. If I can't delegate it and be chill, I shouldn't delegate it, because it's not fair to anyone else to make them do something the way I do it. We're all different humans. So weather watching is one of those things for me where I'm like, if I delegate this and we make decisions differently, then it's not going to work. Also, Dr. B will fall asleep in the middle of anything. So I am the one who will take over the weather awareness, because if the lightning gets awesome or the wind gets too windy, I'm going to be up looking at it anyway. Like, I'm just going to get up looking at it anyway. So I might as well be the one that's going to be up. I am totally fine napping during the day. I'll figure it out. So I can't delegate it. There are some things I can delegate. I'm really trying on loading the dishwasher. I mean, but objectively, there's a right and wrong way. And like, why? Why is that? There's actually a right and wrong way, but other things I can absolutely delegate and let Dr. B do them. It's just gonna be fine. Weather watching, I have no chill. So the funny thing is that near where we live, because we're out in the country a bit, the sirens more often than not also kick off the yapping of the coyotes. So it's like tornado sirens, and then like all of the howling of the I think they're coyotes, the wild dogs of whatever type they are, and they all start going off. So there's no sleeping through it. And then of course our cats are just like, hey, something's weird. What's going on? Something's strange. But last night, hail, wind, rain, trees down. We don't have any flooding. It's all good. So Wild and Free Neurodiversity said, okay, but now I need to know, Emily, what is the right way to load a dishwasher? Here's all I'm going to say. It depends on your dishwasher, but most dishwashers are set up with an area for bowls, and the bowls need to face a certain way. So like the water gets into them. My husband tries to put things in the dishwasher that are objectively not dishwasher safe. And he's like, I don't understand why that's bent. Sir, what? There are things that go top shelf, things that go bottom shelf, knives go down. You don't put spoons next to each other, because then they spoon, and then the one doesn't get clean because the spoons spoon in the dishwasher. But it really depends on your own dishwasher. But then Dr. B will try to do something like put a cutting board that blocks all the water getting somewhere, because he's like, it'll fit. We've finally, between Travis and I, made Dr. B aware that our beautiful new knives that we got for Christmas, we went, quantity over quality with kitchen knives this year, because Travis loves to cook, and it's a whole thing. We love doing a household Christmas gift. So they're beautiful knives, but the dishwasher will ruin the nice knives. So it's like the butter knife, yes. The nice knives, what are you doing? So all of the things. So today, now that we've heard like Emily's thoughts on letting the things go that you won't get mad about, and taking responsibility for the things you will get mad about. And it takes work to be like, no, I can let it go. It doesn't all have to be done my way. It's fine. Hyper independence is sometimes not a good thing. It's just a trauma response. Thanks. Sometimes it helps to be chill. Know the things that you can't be chill about, and just be like, you know what? I'm not mad that I'm doing it, because I can't be chill if somebody else did it. It's fine. So today we're going to take a look at, again, the lawsuit over the buffer zone. I saw some of you asking, what is the buffer zone? In the Karen Reed case, the court has set up a buffer zone where you can't have people on the street talking with signs, with shirts, with, I don't want to call it protesting, because it's not really, from what I've seen, protesting. It's just, I don't know, expressions of support of any side in the case. I think that's the more appropriate breakdown of what it is, but no bullhorns, no honking, no signs, no shirts, no buttons, no blah, 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 blah. So the buffer zone is a little bit expanded to what it was in the last trial. And there are concerns, right? Because the court has the room and the ability to protect the jury from outside influence. But individuals have a right to make their voices heard. We live in a First Amendment world. So there are often in court tensions between someone's rights and the ability for the court to control the court environment. And those things bump up against each other. And we saw that in Idaho, and we're going to talk a lot about Idaho next week. In Idaho next week, we're going to talk about what people can and can wear into the court. And I think the court has like circles of control of what they can control. It's easier for the court to control the behavior of lawyers. Lawyers are regulated by their bar, they're regulated by court rules, they're regulated by all kinds of stuff. So regulating the lawyers is one of the easiest things to do. But even the lawyers have, the right to present their case the way they want to present it. So there's the rights of the lawyers, and then you go to the rights of the people inside the courtroom. Judges have the ability to control the decorum of those in their courtroom. So the rights when you come into a courtroom, you can't just stand up and start screaming at the judge. You're going to get, hauled out of court, barred from court, held in contempt, whatever. And then those circles move outward when you get into outside the courthouse, public spaces, and beyond. So we're going to talk about that in that buffer zone lawsuit. Again, we saw it in Idaho with rules about what people can wear inside the courthouse, different than trying to control people on a public street. We have seen it in the Corey Richens case, a case that I'm very interested to get back to and ready to cover live, but the court doesn't want it live streamed. The court had a bunch of rules about how they're going to do jury selection and really trying to limit the influence. We saw interveners in back to the Koberger case in Idaho with the media saying you can't just block us from talking to everyone. Sure, you can block the lawyers from sharing things that they haven't presented in court. You can restrict lawyers in some ways, but you can't really control the victim's family from whether or not they can give a media interview. There are some things that are a bridge too far. And in Idaho, the media coalition came in and said to Judge, you can't forestall all of this conversation. What are you even trying to do? So we're looking at really expanding circles of what the court can and can't control and where rights bump up against each other. And I think in the Karen Reed case, where it's difficult is when we talk about the way that people are making their voices heard. And so as we talk about that case, I'm going to ask you guys to think about it in two ways, because right now, most of what I've seen from outside of court is people that are supportive of Karen Reed, do not like this case that is going forward, and it is a full free Karen Reed situation. But if you had a case where it was that much energy trying to convict a defendant, at what point is it unfair to a defendant if those outside of court are trying to sway the opinion of a jury walking in and out of court? And at what point can that be chilled or restricted by the court? And what are the boundaries of that? So what I appreciate is that when the court put the order down, those that think the order are unfair is like, you know what? We're going to go to court. We're going to take it to court. We're going to follow the process. There's a process to push back on this, and we're going to follow the process to push back on it, because you want to make sure that juries are not swayed, in this case or any case, that juries are not swayed by the court of public opinion. Individuals should be convicted on the evidence presented in court if the jury finds that that evidence proves that they did the thing they're charged with beyond a reasonable doubt, not because they're afraid that people are going to come into their business or find where they live or dox them or harass them or try to get them fired or whatever it is, if they don't vote the way that public opinion says that they should. Those are real concerns. So where are the boundaries of that? And when can those things be implemented? That's what we're going to talk about. But we're going to first look at the court giving essentially, I think, and I haven't watched today's live jury, I think it's going to be about an hour. We're going to put on 1.25, and we're going to go through the hearing from today, and then we'll go through that lawsuit. So again, replay crew, everything will be timestamped, and we'll go through and see what the judge told the jurors that came in today. Today, it was less jurors that came in. I think it was only about 40, but I will pull that up and give you the lowdown on that. Morton in the chat said, how long will it take to find the amount of jurors needed if 7 were found so quickly? That's not what I meant to do. It's really hard to know because the amount of jurors they're bringing in are not just going to the Karen Reed case. There are other cases going on, and it's hard to really know what a group of jurors will come in with. You could get a group of jurors coming in and a large number of them have heard about this case lightly and don't follow it. You could get a group of jurors coming in randomly that are like, I get home, I put on the YouTubes, I want to know everything about this case. I want to know. So it really depends group by group by group. And it could go quickly. It's gone pretty quickly so far. And I appreciate how quickly it's gone so far. So we'll see. I think this trial will start sooner than the last one, but I might be wrong. So look, here's what I'm going to say. Get the Lawnerd app. We built it free for you. Because when we get to opening arguments, statements, Emily, opening statements, sometimes it feels like they're arguing with these lawyers. When we get to opening statements, you're not going to want to miss a minute. I'm not going to want to miss a minute. And this trial might start faster than we thought. Fingers crossed. I actually really hope it does. I hope it doesn't take 3 weeks to pick a jury. I'm ready to go. We got shit to do in May. I want to watch the Corey Richins case. It's going to be on a delay no matter what we do, but I'm ready. I'm ready. Let's go. Let's pick a jury. Let's go. I should just roll the intro and we should just get going. We got lots to talk about today, so let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not Let's get into it.
Y'all, I'm just pulling up our video from today. We are going to watch jury selection from this morning. Then we'll check in on where they are with jury selection. Then we will go to that lawsuit with the court. And then I will check in on a couple of the motions from the Commonwealth. These are things that are going to play out as we get closer to court starting. Next week, I am going to really switch gears. Asterisks, unless this trial starts, because there are hearings in the Koberger case. If we do not get those covered live, we will make it up in some way. We will figure it out. We're going to be streaming a lot, but there's a ton going on in Idaho with the motions in limine. I want to get into those. It is my plan to just cover Koberger next week. So for those of you that are Karen Reed fatigued, I feel you. We're going to switch gears next week. And it is my thought that they will still be doing day-by-day jury selection next week. If they're not, then we will switch gears and we'll figure it out. So we are ready to go. Cammie asked, Cammie said, what's your zodiac sign? Emily, has to be Earth. My sun, moon, and rising sign are all Earth signs. I'm sure this is shocking. I'm sure this is shocking. So I am a Taurus. I am a Taurus-y Taurus, but we can get into rising signs later if we want to. But yes, all. My chart's wild. We can talk about my birth chart at some point. Emily, when you talk about loving everything, oh yes, all of it, from Myers-Briggs to astrology to human design. I love all of the personality stuff. I love it so much. I grew up in California, so we love all the woo. And what I love is when you look at kind of the beginnings of law. Emily, you're going to get into the weirdest shit ever. When you look at the beginnings of law and you start to look at the blend from Socrates and Plato and the Stoics, and you look at kind of the tradition that they came from, there's this blend of mysticism leaning into kind of modern philosophy and Western thought. And I love the traditions of all of it. I also love the traditions of like folklore as teachings, and it's just love it. Megan B, that's a spicy mix. Megan B is like Taurus, Scorpio. Husband is Taurus, Scorpio mix. It is a spicy mix. We love it. You're gonna get shit done. Like getting shit done. Love. So the car said, if the car didn't hit, you must have quit, says it explains so much about your debate skills. Oh, we'll talk. another day, if y'all want to talk about all of the chart stuff, we can. Today's probably not the day, but we can. For those of you asking, have I done Enneagram? All of them. All of them. All of them. Yes, I have. All right. We're gonna go to court. I sidetracked because we were talking about earth signs. Yeah, yes. So it is we are just, yep, very, very earthy. Which is good. Also, here's where it gives me comfort. When my husband is like, do we really need that class of hotel room or that purse or whatever it may be? I'm like, yes, I do. Everything about me says girl needs to be comfortable. We're going to find a way to be comfortable. Your girl must be comfy or nothing is going to work. It just won't work right. It has to be. I do indeed. My brain will not work if I am not comfortable. The chair has to be comfortable. The office has to feel comfortable. I need the proper temperature. Like I can't. We need to be cozy. All right. For the kids said Koberger case is really popping off. Yes. Which is why we're going to be covering it so much next week. It's hard as cases are getting ready to go to trial together, but Koberger has a little while because it's not going to start till August. All right, let's pull up court. Emily, did you share your screen yet? No, I didn't. I was chatting with the law nerds. You guys go ahead and chat about it. I'm not going to tell you to stop. I think it's perfectly on topic talking about your birth chart. I know there are people who are like, oh, hate it. I love all the personality assessments. I do. I love them all. Because at the end of the day, you still get to make your own choices, but it's really interesting to explore. Oh, well, what about this? What about that? What about this? Just the same way I want to explore understanding my ADHD more. I love it all. Look, I'm here for all of it. Let's add, there are definitely times in court where I'm just like, I need to know more about this lawyer. Like, what are you doing and why? Like, I have questions. There's definitely times. All right, let's put up our little live court so we know we're in court. This is from today. They did this yesterday. Same. But hey, this is a much grander courtroom than the first trial. So a lot of you have told me that they're going to be staying in this courtroom for this trial. We will see. Kimberly, there are tons of places online that do them free if you know your location, date, and time of birth. So I know Astro Cafe does them. Channy does them, I think, for free. There's a bunch of them. So let us continue on. Hopefully we have good sound. I didn't turn it up. That's user error. I should swoop because I'm really ready for some hear ye's. I'm really ready. So Millie says, here on the lucky side of Middle Tennessee, hoping my hubby is safe at work from the storms in Nashville. Glad EDB is live. Me too. We are good. Hubby also went to work today. I'm like, yo, be mindful of the flooding, but he's at work in Nashville today too. So we're keeping an eye on the storms for sure. It is a different only fan. I like the clock though. I wish they would go back to the clock. Let's get to court, shall we? It's going to be a lot of the same. We'll turn it up to 1.25 when we need to. Oh, that sound's not coming through the right way. Hold on. Fail, Emily. Absolute fail. Oh, you know why? Because after the members only last night, it was great to see you. After the members only last night, T came into my office and wanted to rewatch his WGI program, and I'd moved the sound. Because he wanted to watch it again because there were some things he hadn't seen and he wanted to watch it on the bigger TV. So T was like, "Ooh, wait, can we watch it again? Can we watch it again? Can we watch it again? Can we watch it again?" Gen V, because we got on a tangent. We just got on a tangent. That I tangented. So there we go. There we go. Jim, give us the hear ye's. It's not Jim that does the hear ye's. I'm ready for the hear ye's. I'm ready. Oh, I have to move this back from where I moved it yesterday. There we go. We are moving things around. So the jurors are going to be coming in. And yeah, we're in court. I'm just waiting for the hearies. I'm not zooming until we get some.
All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court, and before the County of Norfolk. You are here, if you're attended, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
There we go.
I'm sorry, could you stand and raise your right hand one more time?
Jim's going to swear them. This is
I
the
need you
new
to stand and
veneer of
raise your right
jurors.
hands, Jurors, I'm sorry,
New veneer of jurors.
my fault. Do you solemnly swear to make true answers to such questions as you be put forth to you by the court?
I think this is the first time I've actually seen Jim's face. In the entirety, like the white balance is fixed today, and the entirety of time we have covered court, I think this is the first time I've actually seen the man's face. Like it's, hello, sir. Good to see you.
So help you God. Thank you. You can have a seat now, promise. May I call the case, Your Honor?
Please.
Your Honor, this is docket number 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
So they're going to introduce themselves.
May I introduce myself, Your Honor?
Please.
Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts, along with two of my colleagues.
Good morning, my name is Laura McLaughlin. I'm the Assistant District Attorney for the Norfolk District Attorney's Office.
Oh, he let them introduce themselves today. There we go.
Good morning, my name is Adam Mallory, Assistant District Attorney with the Norfolk County District Attorney's Office. Thank you very much for your time and attention to me.
I wasn't even supposed to be
All
here
right.
today.
Thank you, counsel. And then
Lally
counsel for the
speaks.
defense, and please introduce your client as well.
All of them.
Good morning. Let's try that again. Good morning. My name is Alan Jackson. I have the
Alan just be Alaning this morning. He's like, good morning, and they don't respond. They're told they can't interact with the attorneys, and he's like, good morning, expecting them to all say good morning back, but they're told they can't interact, and so they're not sure what to say. But yes, everything you do in a jury trial, from how you stand up and turn around, is 100% part of getting the jury on your side. So I'm not surprised that Alan is already like, let's try that again. And for those of you reminding me about closed captions, because you didn't see them, thank you very much. So he's like, let's try that again. And this, some of you, I love it. Some of you are like, I immediately can't. Right. It can backfire. I immediately can't. Like if I wanted to respond, I'd respond, but I don't feel comfortable. He's trying to put them at ease. So we will see.
privilege and honor to represent my client standing to my right, Ms. Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning. My name is Robert Alessi. I likewise have the privilege of representing.
But what do you have
Ms.
for lunch
Reed.
today,
Thank
Mr.
you for
Alessi?
coming today.
We want to know what's in your cooler.
Good morning, my name is David Unetti. I'm an attorney. I have offices in Boston and right here in Dedham. It is truly my pleasure to represent Karen Reed.
You know, he's basically handing out cards. He's like, call me if you need anything.
Victoria George, and I have the privilege of representing Ms. Reed, and thank you for being here.
Good morning, I'm Karen Reed. Thank you for being here.
Not every
Thank
case
you
does
very
a
much.
defendant get to introduce
Ms. Reed,
themselves.
Can you please remain standing for just a moment?
So Karen Reed getting to introduce herself is something that not every defendant gets to do. I think it's appropriate to let the defendant introduce themselves, especially if the court's not worried. Like the court's not concerned Karen Reed's going to be like, and this is all fucking bullshit, yo. Like the court's not concerned that she is going to burn a entire panel of jurors by doing something in court. So
Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth
Some defendants
and you upon
totally
your
would,
trial.
though.
If you'd object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
All right. Good morning, jurors. My name's Beverly Cannone. I'm a judge of this court, and I want to welcome you here today and give you some
I'm gonna put
idea
her at
on how we
1.25.
think your day is going to shape up.
there are 40 in the courtroom today.
I just
put my
want to say
notes?
before we start that jury service is certainly one of the most important civic duties we have. And as a civic duty, it does cause us to be inconvenienced. So we do appreciate that you're here, ready, willing, and able to serve if called upon to do so. And our system of justice simply won't work without you. So we do appreciate you being here, and we appreciate your patience. So today we're selecting a jury in the criminal case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. On the morning of January 29th, 2022, the Canton Police Department received a 911 call reporting an
after the
unresponsive
statement of the
male
case,
party
I
in the
will
snow
speed
outside
this
a
up.
residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported
this
to the Good
statement's
Samaritan
agreed
Medical Center,
upon
where he was later pronounced deceased.
by the parties, all of
The
them.
Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent, and she has pled not guilty to the indictments.
We're going to get into that. Lindsay asked a great question in the chat, and we are watching this again. She is going to say the same thing day by day. So we are going to put it at 1.25. But also, part of my goal with going through this, even though it's going to get repetitive, is to help everyone understand this process. If you've never gone through jury selection yourself, if you are one of our international honoreds, if you ever go through this process, that it doesn't feel daunting and overwhelming, that if you get a jury summons, even though it's inconvenient, you're like, ooh, what's T? Not like, oh, fucking hell, I don't want to go do this. So that is always my goal. When do the challenges happen? If throughout, do we know how many challenges have been used so far by each side? I have not seen anyone keeping track of the peremptory challenges yet, but the peremptory challenges happen as they are going juror by juror, because they're doing individual voir dire of the jurors. Once they do this big panel with all the veneer sitting in the back of the courtroom and they have people raise their hands to answer certain questions, then they go one by one. As they go one by one, then they can exercise the peremptories. The clerk this morning, Jim, said that each side has 16. I imagine they've used some, maybe they haven't, but the clerk and the parties keep track of those, and you can use your peremptories for any permissible purpose. There were definitely some rules about when you cannot use peremptories or what would be an improper purpose to use them for, and I'm not going to get all of that today because that is a whole deep, nerdy discussion, and it is very specific on the case law by jurisdiction. The lawyers know that. It's not really that deeply necessary for our purposes, but it's generally I don't think this juror would be a good juror for whatever reason. It might be that the juror stood up and when Karen Reed said, you know, my name's Karen Reed, thank you for being here, that they went, like, it can be just that, like, oh, nope, they made a face. I'm out, vibes. Like that's your vibe check. Challenges for cause go beyond the vibe check. Challenges for cause are, this juror had this experience. This juror said this thing. They can't be a fair and impartial juror. So you kick them for cause, which doesn't diminish the number of peremptory challenges that you have. So you can think of it as peremptories, vibes, challenges for cause are a reason. Hopefully that makes sense before we speed her up to 1.25 and get into it. Melissa, thank you for sharing your experience. Melissa said, as someone who recently went through a 100-person jury panel selection, it all sounds fun until you get called on the week you absolutely cannot be off work and are preparing for PTO. I guarantee most of them don't want to be there. Melissa, 100% understand, especially if it's busy season. It's really hard. In some jurisdictions, they will let you put over jury selection till it's an appropriate or an easier time. And I've seen people really try to double down with, hey, can I put over jury service until the week of Thanksgiving, the week of Christmas, thinking no trials will go. And then if they get stuck on jury service, they're pissed. But teachers tend to try to move their jury service to summer if they're not working summer school and things like that. But it is something that can be done in some jurisdictions where you can call in and say, can you please move my jury service to this date? So sometimes that works. All right, let's put her at 1.25. Hopefully that answers your questions about for cause challenges and peremptory challenges. This court was allowing the lawyers to look at the jury questionnaires and decide if they agreed on kicking jurors for cause. Not all courts will allow that, especially if they're worried about the number of jurors. So you will see. Heather said you definitely can postpone or change location in Massachusetts. It helps if the jury commissioners will work with you, and if you call in and are willing to work with them, they will try to work with them. Anthony said, do they have a limited amount of challenges? Peremptory challenges are limited. In this case, it's 16. It will vary by jurisdiction and by the type of case. More serious cases, you will get more peremptories. The cause challenges are not limited. They are just for cause. In one of my very first trials, got into like a knockdown drag out with a judge who did not understand how peremptories worked because he was a civil attorney before he became a judge and had never done a jury trial. The site judge got involved, and I was like, this is my second trial ever. Like, I've been a lawyer for 17 seconds. What are we? It was a mess. And the defense attorney was so brilliant. And the defense attorney was just like, I think the district attorney is stating it accurately. And then was like, this isn't my fight, which I respect the defense attorney completely for being like, I agree with the DA, but this isn't my fight. If the court's going to screw over the DA on their peremptories, I'm here to zealously represent my client. She's right. I'm getting out of it. It was incredibly frustrating. Emily, are you still mad? Yep. Haven't you been a lawyer like 20 years? Yep. It's the injustice of the thing. It's the injustice of the thing that pisses me off. Also, if you're going to be a judge, know the rules. That's all I'm saying. It's kind of your job.
The defendant is charged with second-degree murder. She is also charged.
Emily, are you also the one that would get red carded by refs for yelling at them sometimes? Yep. All right, they're going to read the charges.
She is presumed to be innocent, and she has pled not guilty
They're
to the
looking for
indictment.
16. I think 18
So the
would make
defendant is
sense, but they're
charged with
looking for
second-degree
16.
murder. She is also charged with manslaughter while operating a motor vehicle under the influence of alcohol.
Oh, we'll tell
and
this
with
story
leaving
later.
the scene after causing personal injury
There's
or
more to
death.
that story.
I'll describe these offenses in greater detail at the end of the case when I teach the jury the law. But briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that that murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms.
And again, if the Commonwealth wanted to go forward on this case, wanton or reckless seems to be, if they stuck to the wanton and reckless charge, they might be in a better position. But I think the overreaching, again, is going to come back and bite the Commonwealth. So.
And the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, the issue of public interest in this case
that was on
and
the
the
court's
duty
end,
of this
not yours.
court to adhere to the rule of
The
law.
stream buffered for a second.
John Adams said that we are a government of laws, not of men.
I guess we're reading this
and
every
that
day.
the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence in the courtroom at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury,
how they feel about their rights
free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your
Public comment
eligibility to
will
serve on
assuredly
this case,
continue.
I'm going to ask questions to you all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, in the process of filling out the questionnaire, you're provided the opportunity to be more reflective as you answer the questions rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaires, we'll have you come up to the sidebar one at a time so that we can follow up on your answers to the questionnaire and to questions I will have of you. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps picked on a case, a different case from another court.
I'm teasing.
In a few minutes, I'll pose a number of questions to you as a group, and you've just taken an oath that requires you to truthfully answer these questions and all questions put to you. If your answer is yes to any question, I will ask you to raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer may read the numbers from the card. You don't have to get the numbers out now because it will still be a few minutes and I'll let you know. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from serving on this jury.
The initial part of jury selection is streamed. The individual juror questioning is
We hear
not.
ambulances and fire engines going
Non-stop.
by every day, many times during the day.
Non-stop.
And if you're selected as a juror in this trial, will be seated in the courtroom across the hallway. We will hear it even more. So generally, the lawyers stop and I stop talking when we hear it. So if you find a question that I pose to the group is overly intrusive, you can elect to answer that question at sidebar. And I probably have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror.
She did state
and
they
the
will
lawyers are permitted
move
to
to
ask
the
you
other
questions for the
courtroom.
same reason. This is not a test. There is no right or wrong answer. All we're looking for is your best, honest answer to the
Just
question.
be truthful. Just
Now,
the
I have
truth.
a witness list that I'm going to read to you, and it is very lengthy. It doesn't mean that all of these witnesses will be called as jurors, but you will likely hear about these witnesses.
This is
So
going to
I'd ask
scare
that
the
you listen
shit out of
carefully
anybody
because in a
sitting
few
on
minutes
jury
I'm going
duty.
to ask you if you know any of these witnesses. It's alphabetical,
Hundreds.
but it's alphabetical according to first name. So, Aidan Kearney from Jefferson, Massachusetts. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe from Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Clay.
I'm going to zoom. The combined witness list is available. They're going to put every possible witness. I saw questions about why some of these witnesses, when the courts made rulings, might still be on the witness list, including the defense expert, Mr. Easter, because the defense can ask for it to be reconsidered. And it would cause a huge issue if a juror was like, oh, wait, out of 100 and whatever people, that's the person I know. And they weren't read out on the witness list. It would cause a big issue. So every possible witness, even if the court has made a ruling, the defense is going to ask the court to potentially reconsider that ruling. And so they all need to be on the witness list. That's to protect the jury. So you leave every possible person on the list, they're not all going to be called. We're going to zoom past the witness list. So we know. Oh, I find the closed captioning very helpful here. We can see that they are still reading names. Perfect. Also, who alphabetizes by first name? I have no idea why it was done that way. I don't know. Somebody chose it. All right, let's back up real quick because it looks like they're done.
People, so obviously this trial is going to take a while. We've already begun our impanelment process. We will continue to impanel. We don't know how long that's going to take. As soon as we start the trials, the lawyers tell me that their best estimate is that the evidence in this case will take 6 to 8 weeks.
6 to 8
That's
weeks.
an estimate. It's a good faith estimate. We do the best we can to let you know in advance how long we expect something to
Yep.
take. It may go a little longer. It may go a little shorter. If you're selected as a juror, I will let you know at the end of every day. It's my practice to let jurors know where we stand, if we're on schedule, if we're behind schedule, which
She
I
did a
can
good
tell
job
you
with
has
that last
not
trial.
happened, or if we're ahead of schedule. So I let you know every day where we are. That's the best we can do, and it's a good faith estimate. We just want to give you
Shit
as
happens.
much information as we can in advance, as much as we can. We expect that the case will go from 9 o'clock to 1 o'clock every day. We'll take a break around 11 o'clock for 15 or 20 minutes or so. Lunch will be provided to you. We're trying to
Promptly at 1.
take advantage of your time here with us. So rather than
Promptly
break
at
for an
1.
hour to go out for lunch, which usually turns into an hour and 15 minutes or longer by the time we get things set up, we want to keep you here for a lunch break. We'll provide lunch for you, and we'll continue to move the trial forward throughout the day. The afternoon will go from 2 o'clock or so, or right after lunch, maybe 1:30, and you'll go until about 4 in the afternoon. There'll be some days here and there that we won't be in session, and there'll be a few more days that we'll do half days, just morning. So we'll let you know in advance those dates.
Can we know the half days now?
And again,
I would
that's the
love
best we can tell you now. So it might help you if I also give you a preview right now about
have
some
like a
basic law that
dental
applies to
cleaning I'm
criminal
gonna need to
cases like
move.
this. As I've said, it's my job to teach the jury the law, and I don't do that
Can we just-
completely until the end of the trial.
Not every
So for now, I'll
jurisdiction
give you
gives
a
jurors
brief
lunch,
summary of some of the
by the
very
way.
important legal
Some do, some
principles that
don't.
will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to
What
be
do they
innocent.
give them for lunch?
The
I have
fact
no
that she
idea.
was
Sometimes they let
arrested or
them
that she
order.
was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a
She said
person
there
of a
might be a
crime
few
in
half
order to
days.
bring that person to
So-
trial in the superior court. But it
There
is
might be
only
a few
the
half
jury,
days.
in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant
wanna know
not
what
guilty.
days will be
The law
half
does not
days.
require a defendant to prove his or her innocence, or to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of
She
innocence
she
remains with the
communicates well
defendant
with the jury.
until the jury make your determination
And I
after
think
you
the jury
listen and
likes her
consider
quite a
all
lot.
of the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, you accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty.
love
I do not
that
have to
colloquy.
say a word.
I
A
love the
defendant's
languaging of
decision
that.
whether or not to testify has nothing
You break it, you bought it. In all of the other jurisdictions we've watched, I've not heard a court kind of bring it forward as bluntly as the jury instructions here do, which is, you charged me, you proved it. I like the languaging of that quite a lot. It makes it very simple, and I think it's easy for jurors to understand why the burden of proof is that way. I don't have to do shit. You charged me, you prove it. Drea in the chat said it's a very Boston statement. True, it is. There are things I appreciate in different jurisdictions, but this languaging I think is simple and really, really easy to understand the concept. So there is not a jury already. No, there are jurors being picked. So this is a subsequent veneer of an additional 40. They have 7 seated as of the end of the day yesterday. So they are looking for up to 16 jurors. So no, this is just, we're at the very beginning. We're tip of the iceberg.
to do with the question of whether she is guilty or not. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. Now that brings me to reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, but it is not easily defined.
You would think
Proof
it's well
beyond a
understood
reasonable
until
doubt does
12
not mean
people have to
proof
talk
beyond all
about it.
possible doubt.
And then it
For
gets
everything in
confusing.
the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have
Seven's a lot
compared
after
and
2 days.
considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now,
the manslaughter charge is an involuntary manslaughter for count 2. So the jury instructions cover it. I think it's a great question. The jury instructions cover it. So when she was giving the languaging, that was a rude pause for me, but when she was giving the languaging, it aligned with the 3 different counts. So hopefully that makes sense, because the wanton and reckless is the standard for the invol. It's not a voluntary. It's not a intentional, volitional. It's an invol.
our system of justice depends on
Same
judges like
charges as
me and
last time.
jurors like you being able and
Need to grab
willing
my
to make
notebook.
careful and fair decisions. All people deserve fair and equal treatment in our system of
notebook is-
justice, regardless of their race, national
came with
origin,
me.
religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Now, of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision.
This is part of the
Hasty
jury
decisions
instructions,
are
by the
more
way.
likely to
She's
reflect
reading
stereotypes
all of this
or hidden
verbatim
biases.
from what's
Second,
written.
keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon
Yeah,
unsupported
listen to
assumptions.
everybody.
Fourth, as you
Yeah.
listen to the testimony about the people involved in the case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it. So, for jury selection, it is important to know if any of you might have some doubts whether you can accept and follow these legal principles. So go ahead and take those cards out because I'm going to start asking you those questions.
And now
But
they're going to get into the
before we
group
begin,
answers.
I understand that sometimes jurors do not fill out the juror questionnaires completely. Sometimes we're in a rush to get those forms back in, or sometimes we think that maybe our experience doesn't apply to the question that's asked. So when you come up to sidebar, if we see that something's missing, sometimes people forget to put in a work experience. Many times people forget to put in their age, and we do ask about that. We need that for purposes of this impanelment. But sometimes people forget to put in whether they were a witness in a case that was in court, a defendant, another litigant. So if there's anything that's missing, we'll ask you. But if you know that you didn't put something on there, please let us know at sidebar. All right, so if your answer is yes to any question that I ask, please raise your hand until the court officer reads your number. Do any of you
So,
folks or close personal friend or family
have you
member
heard of
know,
this case?
or have you had any prior dealings with any of the witnesses whose names you heard?
Sheriff number 343, 360,
Oh, she's talking fast because I have her sped up because we've heard this on previous days, and she reads it pretty clearly, so I sped it up. So we didn't have to, we have the benefit of speeding it up from here. So this was earlier today.
Juror number 355, juror number 332, juror number 323, and juror number 312.
Okay, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County DA's office?
Juror number 326, juror number 328.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome?
Which is going
I
to be
see
a
no affirmative
standard question
responses.
for all cases.
Please
So.
raise your hand if you have seen, heard, or talked about this case.
Juror number 319, juror number 317, 352, 353.
Donnie asked how many alternates do these need to have? If I'm the judge, I would want at least one alternate per week. So if you have enough people to get 6 to 8, I would look for 6 to 8. That's what I would look for. So 12 plus 6 plus 8. Though I hear that she's looking at 16.
Juror number 321, juror number 333,
So.
juror number 351, juror number 344, juror number 348.
Yeah, everyone's heard of this case. That's not going to be enough to kick them.
341, juror number 310, juror number 340, juror number 334, juror number 338, juror number 355.
From Ted Daniel this morning, I'm going to turn this down real quick. From Ted Daniel this morning, he said there were 40 prospective jurors in this group that we're watching. 37 of them answered yes to this question. So it is most of the jurors.
12, and juror number 359.
Lastly, juror 329.
So most of them had heard of
Thank you
it.
very much. Could you please raise your hand if you have expressed or formed any opinion with respect to this case?
Should be a smaller number.
Juror number 319, 353, 311, 343, 347, 354, 322, 326, 339.
Juror number 330,
A lot of you have asked this in the chat, so I'm going to pull it up because a lot of you have asked, isn't it easier to ask who has not heard of the case? There can be confusion in that. All the attorneys agreed that they wanted to know which jurors had heard of the case to make the record clear, because what you would hope to see is the 3 questions in a row are going to be, have you heard of the case? Have you expressed or formed an opinion on the case? Do you have bias in the case? And we'll hear that question next. What you want to see is that the jurors who raise their hand on heard of the case, they are inclusive of the jurors that said that they formed or expressed an opinion, and then inclusive of the jurors that said that they had a bias. So what you want to see is that somebody consistently raised their hand for all 3 of those. And you're not going to get that if you say, raise your hand if you haven't heard about the case. So you need to be able to track the answers regarding the case. So it's why they ask it that way, if that helps. Would it be easier to do it the other way? Possibly, but not for the appellate record.
juror number 344, juror number 348, juror number 361, juror number 341, juror number 310.
And the lawyers are keeping notes in their own way on the jury lists of who has heard what.
Juror number 350 and juror number 325.
Thank you. Are any of you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? Please raise your hand.
Lori, at least, 15,000 people in the chat daily. Hopefully no one on the jury.
319.
Thank you.
So that was a much smaller
Do
number
any of you folks
about
have any
bias.
difficulty hearing or any problem with understanding the English language or any physical or mental condition or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict. Could you please raise your hand if you do?
And this comes up quite a lot in cases. Particularly, there are people who are like, I cannot sit in judgment and make this decision.
Thank you.
So you will see it.
Thank you. Please raise your hand if you think you will have any difficulty following the important constitutional concepts that I've described to you. First, that the Commonwealth has the entire burden of proof in this case. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant is presumed innocent and does not have to do a thing other than sit in that chair for the trial.
Margaret, jurors
Would anybody
generally
have
get a daily
any difficulty
stipend
applying those very important constitutional
I
principles?
don't know what it is.
If so, please raise your hand.
in Massachusetts.
I see no affirmative responses. I can tell you folks that after every jury trial, I talk to jurors. And though they may not have been thrilled about having jury duty, they always tell me that they have found the experience to be a very interesting one, and often jurors tell me that they find it to be a very rewarding one. But I do understand that with this case and this schedule, it may be an undue hardship for some of you. Let me tell you what I mean by undue hardship. When I told you earlier that all civic duties cause us some inconvenience, an undue hardship or a substantial hardship is much more than that. It's something that means that it's personal to you, and the person sitting next to you will then have to step in and give up time from their lives. I generally think of it in terms of either you're a student or you have airline tickets or surgery scheduled for the time that we will be on trial. So with that in mind and that very rough definition, please
She
raise
did
your
talk
hand
to
if
them
you
after the
think
last trial.
that
She just
you
didn't
have a
pull them.
substantial hardship that
But
will
she did
prevent you
talk
from
to them
being a
after the
juror in
last
this
trial.
case.
But it was a thank you for your service.
317, 352.
And so those are the hardships. Those do not automatically get kicked. Those get vetted at sidebar.
54, 326.
Juror number 361, juror number 348,
Michelle Jenkins asked, does ADHD get you removed? Only if you report that you cannot sit in court and pay attention for that time. That's an individual decision.
338,
But no, not necessarily.
juror number 310, juror number 341, juror number 350, juror number 323, and juror number 325.
Okay. So in a minute, I'm going to leave the bench and give you an opportunity to fill out those supplemental questionnaires. I ask that when you do so that you don't talk to anybody about your answers to the questions or to share any comments with other jurors or concerns that you may have about being a juror in general or a juror in this case. If you
Tracy
have
said
any
it's
questions or
$50 a day in
concerns,
Mass,
you
which
can
is
talk to me when we
high
come
for
back
most
out.
of what
So
I've seen.
With that, we will be in recess. Jim?
So
Court, all right, please.
no worries. Invol is number count 2, and then there's lesser includeds of 2. They should have stuck with count 2. But that's on them. It's a very intricate ceiling.
Also, if the jury didn't use the bathroom, you have to stop back.
I don't think they will come back on the record, but we'll take a look with that. I am Ken Ross. At $50, I get nothing because I have a salaried job. Some jurisdictions do that, some don't. In California, you can choose, if you still get paid, if you're on jury duty, you can choose to have your juror funds go back into the funds. So it just depends. So it just depends. All right. Emily Loves Makeup said, is this a different courtroom from last time? It's a larger courtroom. It's this judge's normal courtroom for the voir dire process of jury selection. Let's see if, I don't think they come back on to the record. Nope. That is the end of the intro statements because then they get to one-to-one. Then they get to one-to-one voir dire. So it just is going to depend. All right, let's swoop because that is the end of the public part of the voir dire today. They should be back from lunch now. So I'm just going to take a look real quick at any reporting that's coming out of the courtroom because what I am seeing is from about 18 minutes ago from Ted Daniels saying the court clerk tells me 8 jurors have been seated for the trial, 4 men, 4 women, and the process continues. It says one jury candidate asked if there's coffee with their lunch. The response is negative, Ghost Rider. So that is what that is where we're at with 8 jurors, and yeah, they got to find a way to caffeinate the jurors, right? It's interesting because like one of the trending headlines on the Bird app is jury selection moves slowly in the Karen Reed case. I'm like, who is writing these damn headlines? 8 jurors in 3 days on a high profile retrial is really solid progress, like really solid progress. I'm surprised they're at 8. What? Who's writing this shit? Like, just have what? This is good jury progress. This is good progress in a high profile retrial. It is. They are moving along pretty quickly. So I think it's moving along quickly. Is it what I would expect in a case that nobody had ever heard of that was going to last 2 days? No. But when we're talking about an 8-week high profile retrial, they're moving along quickly. Yeah, the headlines are just not going to do it for me. They're just not going to do it for me. A lot of you are saying no coffee would make me rageful. Look, a lot of the judges that I know put like Keurig machines in their chambers, but in California, the judges furnish their jury rooms out of their pocket. I mean, not that teachers all over the country don't also furnish like their classrooms out of their pockets. Lots of jobs do this, but judges in California tend to furnish their jury room with snacks and coffee and food out of their pocket. So that is how that works. It's also why judges can get so picky about the lawyers having access to the jury rooms. They're like, no snackies. Do not come trolling for food in the jury room looking for some Cheez-Its. I don't want to hear it. It's like, I told Judge Abby, I'm like, Your Honor, you've got to put, coffee back there, some fizzy water. You got to get some Biscoff cookies. She's like, this isn't fucking Delta. And I'm like, but imagine if it were. just like, judge lounge vibes in the jury room. Imagine how happy they would be. Imagine. Miss Crosby's orphaned methodology said, can you bring your own snacks into the jury room? It depends on the courthouse. Oftentimes, yes, but it really depends. It really depends on the courthouse. So, often judges will say you can just bring water into the courtroom, but it depends on the courtroom because I've seen judges get pretty mad about stuff. I've seen judges get into verbal arguments that I thought were going to turn into fistfights. But one of the things I have seen judges get maddest about is people spilling shit on their carpet. So if you are in a jurisdiction where the courts are carpeted, they are going to be much stricter, or if the seats are cushioned, they are going to be much stricter about the water only rule than if you're in a courtroom with like a marble floor. But replacing the carpet in a courthouse is never going to happen. Getting it cleaned is also really difficult. So they do not want, and depending on the courthouse in California, they do not want to attract insects, and they definitely don't want sticky, stinky floors. They get so mad. So water only, depending on the courthouse, it really, really depends. Do you remember I don't remember which Rust trial it was, where the judge was like, if y'all don't knock it off, I'm taking away your coffee? Because she told the lawyers they couldn't have coffee in court. And then when they behaved, she's like, okay, y'all have been good. You can have coffee. That's your treat. And then I don't remember if it was in the first trial or in Baldwin's trial. It was one of the two. But then she was like, if you don't knock it off, I'm taking away your coffee. I think it was the first one. It was Judge Summer. I think you guys are saying Hannah's trial. I think it was in Hannah's trial where she was like, if you continue to act up, no coffee for you. It was giving like, no one's going to recess if y'all don't knock it off. Judge Summer was so tired of those attorneys. Don't make me take away your coffee. Don't make me take away your coffee. So it just depends. But the attorneys had gotten off the rails. Just off the rails. So it's really going to depend. Carla, I remember all the candy during Depp Heard. I was so surprised, but Judge A was like, y'all are adults. I trust you not to leave sticky shit in my courtroom. Look, every courthouse is different. Every judge is different. It really just depends. But some of these courthouses, man, are really prone to insects, and it's not good at all. So, Ted Daniel had gotten a lot of questions. Some people were saying, I've heard it's only 7 jurors. And he said, no, the court has said it is 8. At the end of the day, I will let you know in the app how many jurors they are at, and we'll keep an eye on it and see where they're at. Really, what I'm interested in is where they're at with jury selection at the end of the day tomorrow. That's what I want to see, because we'll get a really good idea. They're not going to start opening statements. Never say never, Emily. They're not going to start opening statements late in the day on a Friday. If they have an entire panel tomorrow, they'll do opening statements on Monday, more likely than not. So we will, I will update you tomorrow in the app. I'll update you today in the app with how many jurors they're at. It looks like they're targeting 16. I wouldn't be surprised if they had more, if they went with 18, but we will see. Let's see. I'm looking real quick at a note from just a moment ago about my local weather. Give me 1 second. Let's see. Oh, good. More tornado watches. All right. Thank you all in the chat for letting me know. I am not surprised, but my phone will go off if we get a warning. So I'm just going to be tired this week. We're just going to be tired this week. The flooding is really the thing. If any of you are local, I can't recommend enough Nashville Severe Weather. It's Nash Severe WX. They are fan funded. If you are in Williamson or Davidson County, they are incredible. I love Ryan Hall, y'all. I really do. Ryan Hall covers a tremendous amount of area and does an incredible job with it. Nashville Severe Weather just covers 2 counties. So Ryan Hall, what I love is I get the overview of what's going on before it even gets into my area. But Nashville Severe Weather will dial that down for you for just your local area. So it just depends. Ryan Hall was live over the overnight shit last night. I was like, at like 9 p.m., I'm like, you know what? I'm going to bed because I'm going to be getting up in the middle of the night because those storms came through middle of the night. Just middle of the night. But yes, the flooding is going to be a huge problem for Nashville. They are expecting kind of historic level of flooding. If you are going to be heading to Nashville on vacation, keep the weather in mind. So I'm going to answer some super chats, and then we're going to talk about the lawsuit. Yeah, he went live like in the middle of the night last night. Look, he's busy in the spring, just like I'm busy in the spring for different reasons. But the one thing I do know about court is most of the time we're going to keep court hours. Sometimes it's going to be a little earlier depending on what time zone the court's in. Sometimes it's going to be a little later, but I know we're generally going to be on working hours. Weather just really likes to pop off in the middle of the night, and it got a little too sunny today. It just So, the weather channels, a lot of the time that people need to take cover is going to be not during working hours. So hopefully Ryan is getting some sleep. I need some sleep. Anyone who was up last night with these systems needs some sleep. I don't think I've actually gotten, with the amount of storms that have rolled through and the amount of warnings that there were last night, I've not gotten a decent night's sleep since I was in New York. And I don't sleep well when I travel. So it's been like 2 weeks. So this weekend, all I'm going to do is sleep. So we're ready for trial. Susan Jane, thank you so much for the 10 gifted memberships. It's good to see you guys. Cindy Orr said, glad to be here today as I contemplate retiring. Cindy, when I retired from the DA's office, it was very bittersweet, but it was a retirement. And then I transitioned into something else. Dr. B also retired before he moved into teaching. So sometimes a retirement is just closing of one door, opening another, and that can be a really exciting shift. So it's good. Let's see. Froggy Gaming said, hello from Massachusetts. Emily, do you think you'll be covering the report coming from the independent review of Canton PD? Froggy Gaming, I was going over it last night on the members only, and I will be talking about it more on the Emily Show podcast on Monday. There are some other cases we're going to check in on Monday. I'm going to try to keep the Karen Reed stuff out of the podcast on Monday because we've covered it so much on stream, and touch base on some of the other cases I'm covering. That report will probably be the only thing I touch on that touches back to this case. It's a lot to go over on stream, so I want to summarize it, and then it's a public document, so I will link it. Minnie the Goose said, Emily, I've been waiting for you to go live to say I was so excited to hear about WGI. I competed for so many years. Minnie the Goose, thank you so much. And it is one of T's favorite things. He is narrowing down colleges, making sure that not only they have a marching program, but a WGI program, because Winter Guard is he just loves it. The kid's got a pretty extensive notes app, note of shows that he wants to create. He just absolutely loves it. And I love seeing him excited about a creative outlet. We all need them. I don't care what the creative outlet is. We all need a creative outlet. I think it's why so many lawyers have other hobbies. Whether it's writing, a lot of lawyers write. Some lawyers, I think, see their hobby as like fighting on social media with each other. I don't think that's maybe the best way to blow off steam, but a lot of lawyers have hobbies, a lot of musicality with lawyers, a lot of storytelling, art. And of course, from the lawyers you guys know on the YouTube, you've got woodworking and leatherworking. And I think Peter just does physical things like the pickleball and all the rest of the stuff and cheering for Florida. Like everybody's got some type of an outlet and it is needed. I think Alessi's has to be Scrabble, has to be Scrabble. Matt, the future ESQ. Hey, I'm taking a class on American law history. Matt, I hope it's fascinating. Are they making you read Crime and Punishment? You'll have to let me know. You'll have to let me know what you're reading in American law history, because the tradition of American law is really interesting when you look at how it carries over from England. I think it's fascinating. Cindy, you're welcome. It is a difficult decision, but it's not. It's opening a different door. The Craft Witch Rachel said, EDB, I bet Alessi still plays the Daily Wordle. Oh, 100%. 100%. Paige said, so glad to have you guys body double today. You're welcome. You're welcome. Laura said, Hubs is obsessed with weather. I never have to worry. See, that's what it is. You got to have somebody who's interested in it. I'm the one that wants to keep an eye on it. Sarah said the Northridge quake was life-changing. Yeah, you definitely know people who have been through Northridge will find a way to tell you they've been through Northridge, but it was one of those things. It's like, where did the PTSD start? It's like, where do I begin? The earthquakes definitely change your relationship with where you live a little bit. Lindsay said, we never did a side quest to the hair last night, but the hair is fire. Thank you. Missed the purple a bit, but it does look great. Thank you. It had gotten way too maroon, so we are working on bringing the purple back. It got very maroony. We used a different color this time, but there's more purple like under here, but also my lights are off, so it looks very maroon in the studio. It looks more purple in the sunlight, but I also didn't turn on all the big lights because there was so much light outside a minute ago. So as the light changes outside, we're gonna start having to put the lights back on. But it's a vibe. I'm here for it. Hello, Lace said, it's a cold, rainy day for my 40th birthday. Happy birthday, but I'm glad to spend it with my favorite law nerds. I'm sure the law nerds all already said happy birthday. Happy birthday. Let's see. We're going to get into, we've got more 40th birthdays. Music to My Soul said, good afternoon. Tuning in from the Airbnb for my birthday trip. Hopefully you didn't come to Nashville where it's flooding for your birthday trip. Hopefully it is a fabulous destination. I'm turning 40 today. Congratulations. Emily, can you please give a shout out to my sister Kim, who's here celebrating to me? Music to My Soul and Sister Kim. I hope you are having a great time for the 40th birthday. Have all the fun in the world. It's going to be amazing. Let's see. There's a lot of questions about the buffer zone. I'm going to save those. I see your questions. I'm going to save them as we transition into talking about that with it. Michaela said 2 times I received jury notices. I was in my 3rd trimester. That is definitely not a time to serve jury duty. They would probably have said, okay, you're going to go postpone this You don't want to be there. They don't want you there. The bailiffs are like, what we're not doing is worrying about whether somebody's going to give birth. We're not going to do that. We're not going to do that at all. Michelle, I hope I answered why Mr. Easter is still on the witness list well earlier, but they can ask for that to be reconsidered, and you never, ever know, because if a juror knew him and he wasn't read out and then he testifies, it's a problem. Billie Jean said, my nighttime show is on. Been following this trial through your channel from Cape Town, South Africa. Thank you. You're welcome. Billie Jean, happy to have you here. One of Travis's guard mates' father is from South Africa. His accent is just delightful. He's delightful. It's great. All right. The Chick Eastwater said the Miramar earthquake at 7.7 is horrendous. I can't even look at the news about it. It is a horrible to look at and terrifying. Absolutely terrifying. Let's see. Miss Simmons said, my husband refers to you as Auntie Emily. I'm here to be Auntie Em to our cats. They know your voice from all the streaming. It is what it is. My cats do too, but I talk a lot. So yes. It got really quiet outside. Beck Murphy said, is it normal for a retrial to have the same judge as the first? It is more normal to have the same judge. It would be unusual to change judges, and there would normally have to be a circumstance to change judges, because even though it is a new trial, the knowledge from the first trial helps. So it would be unusual to have a different judge for the retrial. Renew My Faith says, Emily, if this trial leads to a mistrial, can they retry this case indefinitely? Not indefinitely, but they can, if it mistries, they can retry it. And there will be different motions made as that goes on to stop them from retrying it. Each jurisdiction has a different threshold, but it really depends on a lot of things. One of the things judges in California look at is what's the jury split on the hung jury. Is a jury hanging like down the middle 6-6, or is it one holdout? And that can go a long way, especially as you're getting into multiple retrials. But yes, cases can be retried multiple times. Should the Commonwealth do that in this case? I don't think it's, well, you know how I feel about this case. I can't wrap my brain around why they're retrying it now. So it's hard for me to foresee why they would want to do it then. I can normally logic my way around why a decision has been made, even when I disagree with it. I'm having a very hard time with this one. I don't understand how they think this is going to go well. Like I just don't. Let's see. Allison asked, was called for a grand jury shortly after cancer diagnosis last summer, wrote to the office immediately and was recused, but they said I might not get recused twice. Surgery was successful and no radiation chemo. Congratulations on your successful treatment. And it really depends on where you are and when. So if you ever get called again, I think grand jury service would be fascinating. It's different than trial jury. Sometimes you're doing the investigation. And as a grand jury, I just picture, and I've never been on a grand jury, but I just picture grand jurors being like, I would like to see the phone records. Bring us the phone records. Because the investigative grand juries get to send out subpoenas, and then they sit oftentimes like once a month, and then they come back and it's like, what have you found for us? Tell me the tea. Like, I think a grand jury would be so good. I think it would be so good. Some grand juries are just doing indictments, but an investigative grand jury, tell me everything. And again, during doing jury duty like once a month would be so good. Would be so good. So hopefully you get the opportunity to sit on a grand jury again, and it will be fascinating, but I'm glad they worked with you, and I am glad you are in recovery. Perfect. Alan said, I remember in New Jersey that peremptories seemed to be held until the whole jury slots are filled. It really depends on the jurisdiction. Normally, and I can't say normally, in the jurisdictions I have followed closely and worked in, they normally exercise the peremptories before the individual is seated. But what is different in some jurisdictions is if they are doing voir dire by the box, where they put like 12 to 18 up in the jury box and then do voir dire, that person will be seated and they'll go through all the questioning, and then they'll start exercising peremptories once everybody is in the box, but those are not jurors that have been selected. In Massachusetts, they are doing all of that at sidebar, and then people are being seated. It wouldn't make sense for me to seat jurors that have been passed and have been okay, and then to yeet them, because then there's no one to fill them in with because the other jurors have already been dismissed. So it really depends on how they are doing voir dire and where they're sitting people. But it should be, this is the next person up. Do both sides pass for cause? Is anyone issue a peremptory? Oh, everyone accepts this juror, then they sit in the box. So it really, really, really just depends. But you've got to have more to pull from. I am from Cookeville, Tennessee. Yep, which is where the March 3rd, 2020 tornado hit. We absolutely hate storms. I get it. Let's hope it isn't too bad this evening. I absolutely get it. And I see it in all of the different storm chats with people asking about Cookeville. But this next round, the rain's going to be a problem. So Peppermint in the chat asked, and let me see if I can grab this real quick. If they lose all the alternates plus one and they're down to 11 jurors, do they call a mistrial? So it's so interesting that you asked this question, because we did an entire galloping side tangent about exactly this issue. It depends. In some jurisdictions, the defendant can consent to going forward with less than 12. But if the defendant doesn't consent to going forward with less than 12, then generally a mistrial would be declared if you lose all the jurors. But it would have to be a permanent loss of the juror. It wouldn't be a juror that's like, this afternoon I have a medical appointment that I just can't change. And then they're like, oh, well, we've lost a juror, we can't go forward. Like, that would be an unreasonable mistrial. A reasonable thing would be a juror that was ill, or a juror that had a family emergency that was an unknown amount of time. What the court would try to do if they were at the risk of losing their last juror is pause the trial. If a juror's like, I don't know, I hurt my knee at the gym last night and I have to go to the doctor, the court will probably say, okay, we're going to pause for 2 days and see where you're at, especially if the trial's almost done. If the trial has like another number of weeks to go, that's different. If the trial has like 4 witnesses to go, it might be, is there any way we can do another day or 2? So the judge would really try to accommodate that last juror so they don't have to declare a mistrial. But if the worst thing that ever happened was a juror that just like vanished, and we covered that case with the missing juror that was a side quest into Judge Celia and the First Circuit, where a juror had just kind of vanished and nobody knew where the juror was, but they thought they had 12, but they didn't. They had 11 and an alternate, and then they dismissed the alternate, and then they're like, well, shit, now we have 11. And the defendant didn't assent to having 11. They declared a mistrial. It was a wild case, but they couldn't move forward and declared a mistrial. And then the First Circuit said, no, the judge didn't need to declare a mistrial. There were other avenues the judge could have explored at that time and didn't do so. And the judge was really, really rude to the defense attorney, wouldn't let the defense attorney make a record. And they're like, and overturned the conviction. But the judge would really try to preserve the trial and mistry as the last possible option. Judges also really go a long way to try to keep alternates. And when people are invested in a case, you can tell the alternates don't tend to disappear as quickly. But life happens. People have life emergencies. But if it was I'm going to miss an afternoon of jury duty because I have a doctor's appointment or concert tickets or whatever it is, the judge will generally say, oh, we'll be dark a half day, and that'll be fine. So it is that. So Jessica asked, what are the reasons for peremptory strikes? Just about anything except for things that go to protected classes and bias. You can't just kick someone off because of their race, religion, gender identity. You can kick someone off because they seem to not like you. Like if a juror is mad dogging you the entire time, that's definitely a reason for a peremptory. Like if Alan Jackson got up and was like, good morning, and nobody responded, and he's like, let me try that again. And someone in the veneer snarled at him and was just like, the fuck? You think you're funny? That's a reason for a peremptory right there. The peremptory would be hates defense counsel. You would make a little note. Do you have to give a reason? Wolf Kiara, no, not unless you're challenged on it. Not unless you're challenged on it, you don't. And there can be challenges if one side or the other notices a pattern. If you notice that everyone who is getting kicked for peremptory is the same gender. If everyone in the veneer is that gender, then it's not going to matter. But if there are, 4 women left and all of the women are getting peremptoried, then it might be an issue that the other party can bring it up to the court and say, no, we think they are kicking jurors for improper purpose. That would be the same for race. It could be the same for age and other protected classes. Each jurisdiction might have some expansions on that basic principle, but it's basically vibes, except the vibe can't be like, I don't like women. Like you can't do that. But there was, I remember kicking somebody for peremptory I got challenged on, and the defense attorney challenged it, and the judge is like, so you exercised a peremptory on this juror. Can you tell me why you exercised the peremptory on that juror? I'm like, yeah, I can tell me why. I can absolutely tell you why. Because this student said that they've got finals coming up. They're a senior at Cal State Long Beach. They are sitting there seemingly looking down. I think they're flipping through flashcards. They are incredibly distracted by what they have going on in their last semester of college. So I exercised a peremptory because they're not going to pay attention and because they need to focus on like the last semester of senior year and they have finals coming up. So I don't want them to sit here being pissed off that they have to be on jury duty, because then they're going to make everybody else grumpy. One person's energy can impact a panel of 12. If you have generally a jury that's getting along and you've got one grumpy Gus, it's going to ruin the mood of your jury. Like just truly vibes. And that student was just like, I have fucking finals. You kidding me? Go. Just go. Just go. Just go. So that's one of the reasons I exercise peremptories. Vibes. They can throw off. It's like, I don't want to diminish the importance of jury duty, but it's like arranging seating at an event or a dinner party or a wedding or whatever it is. You need the vibe to be good. And so there's normally, like, I love going to the kids table now when we go to like family functions, because the kids table is now like all the adult cousins and it's the best ever. So that's the vibe. But if you throw in some of the other family members, it's going to throw off the vibe of the kids table. Like, we're the kids table. We've been the kids table for as long as we've been alive. You can't just throw other people into the kids table, and you can't bring actual children to the kids table. We want to drink and gossip. Leave us be. But it will throw off the group dynamic if you start throwing in other people. And that's part of picking a jury too. You need to have a good group dynamic. It's almost, for me, the most important thing is jurors that can work together. And if you have one juror that looks like they are going to want it their way or the highway, it's not going to work. You can see the person who's just like, I run this shit. Nope. You really need to have a jury that can listen to each other and work together. And so you've got to also try to find that group dynamic. And it's not always easy with people you don't know well. So do they have a second kids table then? It's kind of become like the cousins table and like the kids table, but yes. Can Proctor plead the fifth during his testimony? This will be interesting. He didn't last time. And generally pleading the fifth has to go question by question. I don't think they would give him a blanket plead the fifth. So we're going to have to really wait and see. Let's see. Why did Judge Cannone say they needed the jurors' ages for the foreperson? I didn't hear her say that. So I didn't hear her say that. I don't know why you would need it. They can generally determine the jurors' ages roughly by looking at them. All right, let's continue on, shall we? We need to talk about the buffer zone. Before, I don't want to diatribe too long and then have a hard stop due to weather. Asking their ages is fine, but I don't know how it would relate to the four-person. But they generally do have their ages. But I don't know how it would relate to the four-person. But yeah, generally their ages is on the questionnaire. That doesn't surprise me. All right, so let's get to the buffer zone because I don't want to have an emergency weather stop, but I did want to ask some questions. Yeah, I didn't want to move on without asking questions. Leslie said I would be mentally and physically incapable of not doing outside research. And that's a reason. When the judge says, is there any reason you can't sit in this case? It would be like, I can't just not. And that's hard. So, Celeste, do they do mock juries? I don't know. I mean, they often do in civil cases. I don't know if the defense in this case, I imagine the Commonwealth didn't. I don't know if the defense in this case would have needed to do a mock jury based on the amount of public input they have in this case. So, yeah. They have so much input. I don't know if all criminal defense attorneys do mock juries anymore, but in civil cases, it is more common. All right. Are we ready to move on? Are we ready to move on? So, are we ready? I'm ready. I'm ready to move on. Let's see. Let's you all have a different definition of how the Commonwealth would do a mock jury. I really hope that one day somebody can explain to me what they were thinking. I just don't know if that's going to happen. I really don't. Let me pull up that, where'd it go? Let me pull up the lawsuit and then we will go from there. I know I linked it in my notes and then I forgot where I put my notes because we were just answering questions and gabbing, as we do. But also, Emily, be mindful of time. The weather is going to time you out if you are not careful, which is very true. And we don't want to do that. I don't want to promise we're going to get to something and then have to go round everybody up and take cover or wait for the generator to kick in. We don't want to do either of those things. All right, let's swoop. Let's get to this real quick. We are going to take a look at a federal lawsuit suing Judge Cannone and others over the buffer zone created in the Karen Reed case. This zone has expanded a little bit beyond what we saw in the first trial, and we went through the judge's order. Maybe it would help to go through the judge's order again. We can take a look at the judge's order again really briefly and then go into this federal suit. I think that might be the most helpful. And then we will talk about the lawsuit over the buffer zone and where this may go in federal court. Will they come up with a response before the end of this trial? We will see. They should take it up on an expedited basis because the trial is underway now. We have jury selection ongoing and witnesses are going to start in the next few weeks at the most. So the individuals that are suing are saying that their rights are being infringed by the buffer zone ordered by the court and are asking for the federal court to tell the lower court no. So let's pull up. I think it makes sense to do it that way. As you can tell, you guys know, you've been here for forever. I do make decisions by talking things through. And I think they will restate the buffer zone in their suit. They should, at least anyway, but I think it would make more sense for us to go through it first. So let me just find this real quick in my notes and pull up that order. Let's see. That's not working nearly as well as I had hoped that it would. All right. Well, nuts. Give me 1 second. Where there are too many filings in this case. And I don't remember exactly which day it was on. Let's see. I'll find it. Miguelina's probably already got it there. No, that's the motion for the buffer zone. That's not it. Where's the order on it? It has to be right down here. Thanks, Law Nerds. This is why I prepare things in advance, but I don't know why I don't see it. It should be right. It should be right there. Does anyone have any idea what docket number this order is? Because that would help. No. That's the Commonwealth's motion on buffer zone. That's not what we need. All right, let me find it in my notes. Because it's gotta be, unless she signed it on this motion. No, that's the Commonwealth's motion. It's gotta be after that. And it is not where it is supposed to be. Miguelina, did you grab it earlier? Do you? No, I didn't put it in the prep document. It's in my breakdown document because I wasn't going to pull it up. I was just going to do it and then I changed my mind. Hold on, let me try it this way. Sorry, chat. It's a good idea in practice until I can't find it. Oh, because I don't have it linked. That's why. All right, it's docket 6:30. Give me 1 second, you guys. That's 100% on me. I read it, I downloaded it, and then I didn't docket it. Brilliant on my part. I had it in the motion, but not the order. So I'm gonna have to go grab it real quick. Thanks, chat. You guys are the best. I appreciate the patience. It won't take me but a moment to go grab it. In the midst of downloading all of the things, some stuff got downloaded and some stuff got downloaded and then not saved, which is completely on me. Here it is. All right, we're just going to grab that real quick. It happened the same day as the motion to dismiss while I was traveling, so I'm not surprised I downloaded it and forgot to save it. So we're just gonna have to do it this way, and that's fine. Because I summarized it last time and didn't pull it up. Hopefully pulling it up will be more helpful. So let me put it where I need to grab it. If you guys ever wonder how long prep takes in this case, organizing documents, which I do myself to make sure I have everything. We see how well that works sometimes. Organizing documents takes a substantial amount of time in some of these cases, not just grabbing them, but grabbing them, making sure they're docketed where I can find them, and then summarizing them is sometimes no small task. Sometimes it's pretty quick, but this case has been so busy lately that it is a substantial task. All right. And then I need to make sure it's somewhere where I can pull them actually up. All right, files, get into the folder so I can just grab you from your home. All right. Perfect. Here we go. Thank you for your patience, chat. We don't, that's why I normally prep for the stream, so I don't have to worry about not finding it, but I changed my mind in the middle and it was helpful. Alrighty. Docket 6:30. This is the court's, yikes. No, stop it. The technology's like, what we're going to do is just mess with everybody. Stop it. It's gonna be good enough. It's gonna be good enough. This is the court's order on the buffer zone before we look at the lawsuit over the buffer zone. Prior to the defendant's first trial on April 4th, 2024, can you believe that we're like a year to the day? A year to the day? This court issued an order establishing a buffer zone around the Norfolk County Superior Courthouse, prohibiting any individual from demonstrating in any manner within 200 feet of the courthouse complex and from wearing any clothing or insignia related to the case in the courthouse during trial. In the courthouse. The Commonwealth now moves for the court. Oh, stop it. Google Drive is just going to drive me just bonkers today. Stay there. You guys, it's just going to fight with me. I apologize. Let's see. The buffer zone was issued during the first trial. The Commonwealth moves for the court to reestablish a buffer zone for the defendant's upcoming trial and modify the previous order by extending it to include area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. Footnote 1. During argument on the motion, the Commonwealth withdrew its request for a second modification to the April 4th, 2024 order. To ensure the defendant's right to a fair trial, the court may restrict protected speech, that is, demonstrating, protesting, etc. The court may restrict protected speech so long as the restrictions do not, quote, burden substantially more speech than is necessary to further the government's legitimate interest. So we're in a full First Amendment balancing test. And the restrictions must not be more onerous, essentially, than is necessary. For the same reasons that compelled the court to establish a buffer zone for the first trial, it is necessary to establish a buffer zone for the second trial to ensure a defendant's right to a fair trial. Let's go to the next page. All right. Let's see if we can. The problem is some of this is a StreamYard issue, which is annoying at best. I want to make it bigger so you guys can read it. It's just not playing very nicely with letting me do that. There we go. We're going to just leave it like that, but we would like it to be big enough to read without it covering up the letters, but we do our best. We do our best. This case continues to garner significant public interest. Stop it. Streaming is dynamic. And today it's just gonna fight with me. This is StreamYard and me fighting. Google Drive just happens to be stuck in the middle of that fight. Some days it works really well. Today's not one of those days. Perfect. This case continues to garner significant public interest. When the matter is in court, individuals line the sidewalks outside the courthouse, loudly chanting and voicing their opinions about witnesses, attorneys, and the strength of the Commonwealth's case. They display matters which may be in evidence during the trial or share their viewpoints as to the guilt or innocence of the defendant on their clothing or on signage. If prospective jurors are exposed to the protesters and messages, she said demonstrators before, we've gotten to protesters now. If prospective jurors are exposed to the protesters and messages displayed on signs or otherwise, particularly before this court has had an opportunity to instruct the jurors about their obligations with regard to remaining fair and unbiased, there is a substantial risk that the defendant's right to a fair trial will be jeopardized. The risk extends during trial where jurors and witnesses would have no choice but to be exposed daily to the message and viewpoints of the protesters when entering and leaving the courthouse or sitting in the courtroom or jury room. We were just trying to move it up. Additionally, the court concludes that modification of the April 4th order is necessary despite the 200-foot buffer zone around the courthouse complex during the first trial on the western side of the courthouse complex, where there is a large open space running along High Street between Bullard Street and Ames Street. The collective voices of groups of demonstrators gathering outside the buffer zone could be clearly heard inside the courthouse. See the affidavit of MSP Sergeant Michael Hardiman. Vehicles honking their horns in response to signs and gestures from the demonstrators could also be heard frequently during the first trial. Indeed, after trial, a deliberating juror reported that during deliberations, jurors could hear protesters outside screaming and yelling. Affidavit of Juror Doe at paragraph 10. Footnote 2. The court also recognizes the list of concerns sent to the court by the, quote, Karen Reed Trial Prepare Together group, a group of local business owners and organizations that experienced issues with protesters during the first trial. So there was the businesses in the area also reached out to the court with regard to their concerns. All right, so the court is saying to ensure a fair and impartial jury, extending the buffer zone is what is going to be said. Let's get to the next page. Thank God it's the last page, because then we can get to the next document. Hopefully it plays nicer. Fingers crossed. Expanding the buffer zone is necessary to prevent jurors from outside influence and to prevent interruptions and distractions during trial. It is therefore ordered that no individual may demonstrate in any matter, including carrying signs or placards within 200 feet of the courthouse complex during the trial of this case, unless otherwise ordered by the court. This complex includes the Norfolk Superior Courthouse building and parking lot area behind the Norfolk County Registrar of Deeds. The buffer zone shall further be extended to include the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. So it is the 200 foot buffer zone plus these other boundaries. Individuals are also prohibited from using audio enhancing devices while protesting, bullhorns, speakers, and the like. Let's see. It is further ordered that no individuals will be permitted to wear any buttons, photographs, clothing, or insignia related to the case pending against defendant or relating to any trial participant, witnesses, law enforcement, things like that. So that is related to inside the courthouse. No individuals will be permitted to wear any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department-issued uniforms or any police emblems in the courthouse. Right. You can't have all of the like police department show up in uniform and sit in the courtroom either. This goes both ways. All right. So that is the order from March 25th. Let's turn to the federal lawsuit about that order now. And let's hope it cooperates. Fingers crossed. Fingers crossed. All right. Let's add that. And also, hold on. I have a visual example from Google Earth. Let me pull this up real quick. In Google. Hold on. Let's see. My amazing producer, Miguelina, made this. It is, let me get it pulled up real quick because it didn't want to pull up just a second ago because of my computer. All right. Let us pull this up and share it. Miguelina made a visual of the buffer zone for all of us that are not Massachusetts residents. And I deeply appreciate it. Thank you. Producer Maggie, you are the best. Let's take a look real quick at the Google Earth buffer zone that they are talking about. So, woohoo! Buffer zone. So, here the red zone is the buffer zone. So we are looking at there's the Charles River. We are looking at the court. There's the district court, there's Ames Street. So we are looking at all of this red zone being the buffer zone for the case now. So again, a visual always helps, especially if you're not from the area, to take a look at how much is encompassed by this zone of where people cannot be around this courthouse. And it looks like a pretty open plaza back in this area behind the courthouse. So, or that's not the courthouse, that's the other building, because the courthouse is over here. But that is a large area behind that other court building. So let's take a look at that federal, for all of you that are like, that's a big old zone, right? Isn't that helpful? The white zone is for the immediate loading and unloading of passengers only. There is no stopping in the red zone. Doctor Who, yes, that is exactly what they said. So it is a large buffer zone, but hopefully that helps. Let's take a look at the federal court order real quick. I'm trying to switch screens. And it just froze. Perfect. Perfect. Thank you. Thank you so much, Google Chrome, for just absolutely being like, who is she? We don't know her. Let's try this again. Again with the federal court lawsuit. Nope. It just doesn't want to share screen. That's delightful. Hold on, you guys. I'm having some slowness on my end. That is probably due to Google. So let me try to close a few tabs and see if it'll help, because it is just, StreamYard is just fighting with me today. Oh, streaming is dynamic. So we're going to have to wait for StreamYard to let me click on anything. Can I click on your questions? No. Can I pull up your super chats? No. Can I pull up and share screen? No. No, I can't. Everything is frozen. Delightful. Can I restart my browser? Also no, because it will take everything out with it. So let's try to just close this window down and see if that will help. We knew we were going to run into something today. I didn't think it was just going to be my browser. But here we are with Chrome just being like, we've done enough today. We've done enough. We've done enough. Yep. So if I am freezing on your end, it's not you. It's 100% assuredly me. Danielle said StreamYard was like, buffer. Buffer zone? Let me buffer. That's how I'm feeling at the moment. That's exactly how I'm feeling at the moment. We just want to get through this last complaint. That's it. Just one more. That's it. We're almost there. We've almost made it. Come on. We're almost there. We're almost there. Yep. StreamYard, I see your buffer and raise you a crash. Look, if there's any day that it's going to do it, I'd rather it not be during opening statements. We'll take it today. We'll make it work. The law nerds are patient. We've answered questions. We've got this. We've got this today. But oh my, has it just gotten feisty? Young Black Economist in the chat said, I agree about Chrome. At least for me, it just uses too much RAM. It does. And I would prefer not to use Chrome for streaming, but StreamYard will not work with audio if I do not use Chrome. So I can't stream on anything but Chrome until our own streaming software is done. I'm so excited that we are building our own software, but it is frustrating because Chrome, as browsers go, is a very heavy browser. And there are times that just is too much. And I don't like not having options at all. It makes me real feisty. All right, let's see if we can share our screen. Fingers crossed. It looks like it's trying to. So, Patty said, Emily, be like, goodbye, stream. Yes. Yeah. And it is just, it will not share at all. It's not going to be any fun to try to cover this without the actual freaking document. So could we just have the whole thing will not share. Could we just have our document, please? Could we just, I see the document. I've gone to share the document. Crashing. Just so dramatic. Oy, law nerds. I'm going to have to restart my browser. We're not going to be able to get to this. So I apologize. Let me put you guys on a quick cortisone break, and I will be right back. I have to restart this browser. My apologies, chat. It just will not pull up the documents. And I would really, 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 really like to finish this today. So let me pull that up real quick. I apologize for the hold music. We will be taking a quick stream break. I will be right back. Just BRB. All right. Hopefully, we will be able to share it now that everything has been restarted. So thank you guys for vibing with the music, and apologies. But we are finally getting into this federal lawsuit about the buffer zone. And then all of the streaming gods are like, girl, just go mind your weather. Like we're done for the day. The weather's weird. Just go take care of the spinny weather. Nothing wants to work. It's gonna be fine. It's gonna be fine. All right. Hopefully, let's see if we can get this one to do what I was trying to do with the other document earlier, which is just to be able to zhuzh it to the side. Nope. Let's try one more time. All right. I just want to be able to make it work the way I want to. It's not going to do it. It's not going to do it. We're going to take what we get today, and we get what we get and we don't get upset. That's how today is rolling. Thanks for your patience, chat. Oh, this is why we get the app. So if it did crash and I needed to send you a new link, you would have the app and I can just send you a new link. So if you haven't downloaded the Lawnerd app at lawnerd.com, download the Lawnerd app because streaming is dynamic. Yay. All right. This is plaintiffs Jason, Allison, Lisa, and Samantha versus the trial court of the Commonwealth of Massachusetts, Judge Cannone in official capacity as a judge, Jeffrey Noble as the superintendent of state police, Michael D. Entremont something, in the official capacity as chief of the police department of the town of Dedham, Massachusetts, and Morrissey as the district attorney. So this is a lawsuit regarding the buffer zone against everyone that's in charge of the thing. The DA's, I guess the DA's office made the motion for it. So that's why we're here. This is in federal court, verified complaint. The Karen Reed trial has drawn significant public attention. I've got to make that a little bigger so I can read it. There we go. Yay. Plaintiffs are members of the public who wish to publicly express themselves near, but not on, the grounds of the courthouse where the second Karen Reed trial is taking place. Their primary concern is that they wish to criticize Judge Cannone. They have been doing so since November 2024 without incident. They have been doing so peacefully. They have been doing so while Judge Cannone presides over cases in the Dedham courthouse, and neither the Sixth Amendment nor the First Amendment have felt the slightest chaff. However, Judge Cannone has found her pretext to shut down protest against her and a noble request from the Commonwealth that an ill-defined quote-unquote buffer zone be declared on the streets, public walkways, public library, and private properties surrounding the Dedham courthouse. The covering private property is a really interesting separate question. So is this buffer zone narrowly tailored constraint on protected First Amendment activity, or is this an overbroad chilling of speech and protected activity? So they are saying that this order is a pretext. I don't think the order is a pretext. I think that how loud it was is a valid concern for the court. I don't know if the size of this buffer zone is needed. What I appreciate is that this is the process to follow. Hey, we think our rights are being infringed and we're going to court. Perfect. That's exactly how I want to see these things play out. Because then the court can take a step back and say, is this too much of a buffer zone? Does the court have the ability to determine what you can and can't do on private property? If you own private property, should you be able to put a sign out that says whatever you want your sign to say? I think it's a fair question for the court to decide. For, again, the federal court to decide. So, of course, this is advocacy. So this is going to be written in much stronger language because this is advocacy. Again, they're saying Judge Cannone is acting out of pretext and wanted to just shut down anyone for doing anything. Excuse me. They say Judge Cannone joyfully entered the order ex parte. I mean, that's speculation. Joyfully entered the order ex parte, enjoining plaintiffs and everyone else who are not subject to her jurisdiction from speaking on private property and on traditional public fora. It is a lawless, ultra vires act that violates the constitutional guarantees of free speech and due process. Cannone has issued this order primarily to quash criticism directed at her, and that, again, they are saying it's pretext to stop people from voicing their displeasure with the judge. I think there are valid concerns about undue pressure on the jury and how loud it can be. My question really is, where are the boundaries of that? And I think finding those boundaries is necessary because the court can't overstep. And when it comes to protected First Amendment activity, it has to be the most restrictive or the least restrictive means, not the most, Emily, the opposite way, the least restrictive means. So is this buffer zone as it's expanded truly the least restrictive means, or are there other options? Kimberly G in NYC said, we put out political signs all the time and they aren't illegal. They're protected First Amendment speech. They aren't illegal. There is, and I talked about this a bit earlier before we got into this topic, the court is allowed to make orders to protect the jury and to protect the defendant's right to a fair trial. It's easier, it's easier to conceive of this if you're looking at perhaps a defendant who you are sympathetic for and protesters asking or trying to influence a jury to convict that defendant. It's a little easier to look at it on the flip side, because I'm sure a lot of you are like, well, I agree with what they're saying, so it's fine. You have to look at the flip side of, if this was undue influence of a conviction of Karen Reed, would you want the jury hearing that while they're deliberating? And what are the zones of control the court has? Inside the courtroom and the attorneys is a stronger zone of control. On the courthouse property is another zone of control. And then as you go out into different zones, where is the limit of what the court can say? You can restrict what's in the courtroom. That's not an issue. You can restrict what's in the courthouse hallways. That's not an issue. You can generally restrict what's on the courthouse property. They do this to reporters all the time. You can only film in a designated area. We have a free press. But courthouses say this is where you have to be to record an interview, or no photography inside the courthouse, etc. But when you get into public streets and other private property, that's where you start getting into these issues of, can the court restrict protected behavior on private property, on other public property? And somebody gave the example in the chat of, what if, like Mothers Against Drunk Driving showed up with a couple hundred people and were protesting to convict Karen Reed. It's what if it's flipped? And I think when it comes to First Amendment stuff, you often find cases coming up with speech that you might not want to protect. And those are the cases that end up going to court. I'm not saying this is one of those cases, but when we're talking about First Amendment speech, it's, I think, really important to look at the flip side of, even if you are on the side of the speaker, what is the flip side of that? And would you still be okay with it? And when you can find that boundary in First Amendments of, I'm good with this, no matter what the person is saying, if they are within this area of the courthouse, then we're good. That's the way to evaluate First Amendment. It's not always easy to do it that way, but it can't be, it's okay for the pro Karen Reed folks, but I wouldn't want the convict Karen Reed folks being able to do this. That's when we end up with a disconnect. My questions on this are not, I'm really not concerned about who the speaker is or what they are saying. Is it undue influence on the jury? Can the judge rule about what people can do on private property, which I'm real fucking skeptical of? How far out on public property can the judge enjoin people? And how can you have that injunction? Those are my questions here. And again, this is, James made a great point in the chat. A reasonable noise ordinance seems valid. Yeah, I think there's a difference between telling people they can't have like megaphones, microphones, speakers, honking, different than you can't wear a shirt on private property. And so I'm interested to see what they focus on. Right now, they are saying Judge Cannone's feelings are hurt and she's just big mad because people are criticizing her. They've gone on to say that Cannone has issued this order primarily to quash criticism directed at her. So they're saying they are not trying to, the speakers aren't trying to influence the jury. The speakers aren't having an action on the jury. The speakers are criticizing the judge, and that behavior is allowed. So let's continue. Nobody outside the box asked, it was okay in Depp v. Heard. Is that because it was civil, not criminal? You still had concerns about what the jury may or may not see in Depp v. Heard. There were limitations in Depp v. Heard about what happened in the courtroom and outside the courtroom, but the parties weren't pushing for it the same way that it was pushed for here. So different judge, different parties, but the civil criminal is not the issue, because you can have this in civil cases too. You can picture a case. God, I'm sure there were cases where people were protesting outside courthouses in some of the big tobacco lawsuits or some of the gun lawsuits. Like, you can see civil suits that people feel strongly about. It's just different. And again, at the beginning of the stream, and will be timestamped, I talked more about this with the restrictions in Koberger that we're seeing. And I will endeavor not to repeat myself. They say that Cannone has issued this order primarily to quash criticism directed at her. As the only protests that have been documented have been the plaintiffs in this case who have quietly held signs criticizing Cannone. To remedy this constitutional wrong, the plaintiffs, and they named them, bring this civil action against defendants that we already named for the infringement of their rights. The parties, and then they list out the parties. I'm not going to go through them. We've named them already. They're within the jurisdiction. Let's go to the factual background. On or about January 29th, 2022, John O'Keefe, a Boston police officer, died. On or about June 9th, 2022, a true bill, so an indictment, was returned in the trial court of the Commonwealth of Massachusetts Superior Court Department, Norfolk, indicting Karen Reed and charging her with the second-degree murder of John O'Keefe, killing John O'Keefe with her motor vehicle while intoxicated, and hit and run. that's not exactly how the charge reads, but hit and run death of John O'Keefe. It is hit and run causing injury, causing death, but either way, same. Defendant Cannone is the presiding judge in the Reed prosecution in the case styled Commonwealth, and then they give the case number 0017 in the trial court of the Commonwealth of Massachusetts, Superior Court Department, Norfolk County. The Norfolk County District Attorney's Office, led by Malcolm Morrissey, is prosecuting the case. A trial in the Reed case was held into 2024, which resulted in a mistrial after the jury failed to reach a unanimous decision. The second trial in the Reed case began April 1st, here after the second trial. Prior to the first trial, the Commonwealth filed a motion to create a buffer zone beyond the grounds of the Norfolk Superior Courthouse to prohibit any individual from demonstrating in any manner about Reed, law enforcement, the DA, potential witnesses, and evidence within 500 feet of the court complex during the trial. Massachusetts citizens, and then it names the citizens thereupon moved to intervene for the limited purpose of opposing the Commonwealth's buffer zone motion. The motion to intervene was denied by the judge, who declared that the citizens had no right to intervene, even though the order would directly affect them. This is the first trial. And we saw this in, I think Koberger is the example that comes to mind because it's the case that's also front of mind at the moment, that when the initial non-dissemination or gag order was issued by Judge, there were interveners from the media that said, no, you can't just issue this broad of an order. And the media intervened because their rights were being impacted, they said, by the court's order, and they were heard by Judge, and it didn't change anything, but they heard from Judge. Here they're saying in the first trial, individuals who wanted to be able to exercise their rights near the courthouse sought to intervene, and the judge said no. Citizens, I think, do have a right to intervene. It is their rights. Who else's rights are there? You've got the defendant's rights, and then you're creating a buffer zone. The buffer zone doesn't impact the defendant. The defendant's in the courtroom. It doesn't impact the attorneys. The attorneys are in the courtroom. It impacts the public. The point is to impact the public. What is the point of a buffer zone if not to impact the public? How can you say they don't have a right to intervene? They have a right to intervene because it's their First Amendment rights. The media was like, nope, we're staying out of it. Nope. No media intervention in this one. Not at all. But I think the media probably has a zone because it seems that they are allowed to broadcast closer to the courthouse because they are not, quote unquote, demonstrating, right? Okay. They said that Judge Cannone then, this is first trial, Judge Cannone then issued an order granting the Commonwealth's motion, asserting that the Commonwealth's perceived inconveniences overcame everyone else's First Amendment rights. I mean, I imagine the order was that the defendant's right could be impacted by a jury being swayed. But they say that the court granted that motion without regard for any differentiation between members of the public and expressly ordered that no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial, unless otherwise ordered by the court. The complex includes the Norfolk Superior Courthouse building and the parking area next to the County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting. That makes sense to me. I don't think that that is an inordinate restriction in close proximity to a courthouse. I'm sure many will disagree with me, but the audio enhancing devices, I get. Like that, I get. The lawsuit goes on to say speech that does not qualify as a demonstration was not restricted. Thus, a nearby cafe could advise breakfast using a bullhorn and parade its menu on picket signs and placards. Celtics and Bruins fans could similarly honor their teams by hooting and hollering and carrying placards. This is part of the problem too. If the noise is the issue, shouldn't it be all noise? And in fact, commercial speech was permitted within the zone. In advance of the second, I don't know if any of those things happened, but it's fair to say you are restricting specific speech based on the nature of the speech. And again, they need it to be the least restrictive. I think saying no bullhorns is a tailored, if the concern is the jury being inundated and disrupted, the noise restrictions seem to be reasonably tailored to that. But you can't tailor a solution based on the content of the speech. So, all of you are saying, can't they restrict the sirens? Right? We're getting into full-on law school. Look, I hope law professors are paying attention to this case. I'm sure some are, because this is a great real-world class hypothetical when you're talking about all of the means tests with First Amendment speech. Where are the boundaries? Is it a bullhorn? Is it a sign? Is it a sign with flashing lights? Is it a t-shirt? Is it a button? What if the button makes noises? What if the bullhorns just make siren noises? You're not saying anything. You're not enhancing your speech. What if you're just making siren noises all day? Because the siren noises are happening. What about then? I don't want to give anyone ideas. I think it's horribly distracting to the jury and would give everyone a fucking headache. But for the hypothetical purpose of this, what about that? So, again, fair point. They go on to say, without an opportunity for affected persons to intervene or be heard, the judge issued the order on March 25th, granting the Commonwealth's motion, asserting that the basis for the first motion was warranted a larger buffer zone for the second trial, and expressly ordered that no individual may demonstrate in any manner. So it is targeted at whatever demonstration is. Grayspace, you've absolutely made my day. Grayspace said, EDB, your Supreme Court TikTok hearing coverage is why I could read this and be like, I know about strict scrutiny. Look, man, we're doing the law nerd university here when we're talking about levels of scrutiny. Woohoo! I'm so glad that we understand where scrutiny applies and where it doesn't apply, and the way to think about the First Amendment in law school. The way I thought about First Amendment was like, if somebody was saying the thing that was the most offensive to me or the most offensive to you, that's the speech I kept in mind. Where is it? Where can it be restricted? Where can't it be restricted? And go from there. It's so easy to evaluate First Amendment in context of speech that you like. It becomes much harder in the context of speech that you find personally abhorrent, offensive, etc. So I always took First Amendment cases and went, what if this deeply offended me? And then took it from that lens of, I don't like this speech, but that's not my call. And that's one of those things lawyers do really well in trying to argue the rights, even when you're arguing the rights of the side that personally you might not want to see. So for all of you, as we're listening to this, a lot of you are like, I get it. We've got to think of it through the opposite lens, which we might not need to do as much in this case, but I will try to. So that was my approach in law school, to try to wrap my head around First Amendment speech, which ends up with really wild hypotheticals about people saying abhorrent shit. But that's really how it kind of plays out, because oftentimes when First Amendment stuff comes up, it's about awful stuff that people are saying. Prince Lover says, how is it enforceable? It's a court order. So the same way any court order is enforceable. So it would be the violation of a court order. Let's continue. Without opportunity for the affected persons to intervene or be heard, which is a problem. Did people file in this one? I don't know if there was an intervener, if interveners tried to file. It sounds like the first time they did. I don't know if they did the second time. But we'll see. Hopefully they'll point it out if they did file, because I don't want to see the appellate court go, well, you didn't even bring it up. You didn't bring it up this time. Because if the only time they filed to intervene was in 2024, the federal court might say, but you didn't ask the court to intervene this time, therefore this isn't ripe yet. Go ask the court, then get denied, then come back. And that could happen. So hopefully they'll, because I don't remember seeing it on the docket, but I might have missed it. So I'm not going on my memory. Hopefully they'll point it out later on. The court issued the order on March 25th, 2025, granting the Commonwealth's motion, expanding the buffer zone, expressly ordering, quote, no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial of this case, unless otherwise ordered by the court. This complex includes the Norfolk Superior Courthouse building, the parking area behind the County Registry of Deeds building, which I think is that large space that we saw kind of jutting to the top of the map. The buffer zone shall further be extended to include the boundary areas of Bates Course, Bullard Street, Ames Street, and Court Street. Individuals are also prohibited from using audio enhanced devices while protesting. See Exhibit C, second prior restraint order. So they are talking about prior restraints on speech, meaning you are stopping people from speaking before the shit's out of the horse. For the past several months, plaintiffs have been engaged in peaceful demonstrations with no adverse incidents. Such demonstrations took place in the location that is within the buffer zone of the second prior restraint order. For example, plaintiff Jason peacefully demonstrated on the sidewalk next to the courthouse holding signs that read that Bev's Court is a clown show and others regarding with images of DA Morrissey and Judge Cannone. Such demonstrations were specifically about Judge Cannone and occurred during trials presided over by Judge Cannone. There were no disturbances, incidences, or interference with any of the trials taking place, but Judge Cannone was apparently embarrassed and annoyed. This is hyperbole. Embarrassed or annoyed by people protesting against her. Nevertheless, nobody's rights were impeded upon, and no one complaint was received that plaintiffs were aware of. Plaintiffs wish to continue demonstrating, and they have a right to do so, including criticizing Judge Cannone. They have a right to do so. We take a different tack on that in chat because we don't attack individuals in chat, but we take a different tack in chat because we don't devolve into like name calling and commenting on people's appearances. But y'all have made your thoughts known. I mean, a lot of you do not like this judge. You have made those thoughts known and done it very, graciously. And I think we lean very hard as law nerds into these are the judges we love, and then we don't talk about the other ones. So it's true. Gray space is like the First Amendment does not protect you in the chat. No, we have chat rules to keep things civil, and we love it. Diplomatically, Helena said diplomatically. Yes, diplomatically, because you can dislike somebody and still not call them names, insult their looks, and things like that. All of you are just like, nope, not for me. Don't like it. But then you're also able to be fair and say, you know what? She has a good demeanor with the jury. I think that's what's frustrating about this judge is her demeanor with the jury is good. She keeps them in the loop, but does not have the same patience for the lawyers, which can be very frustrating. All right. Plaintiffs wish to continue to demonstrate, including criticizing the judge, which demonstrators who are not lawyers can do. Lawyers have different rules for that, off the grounds of said courthouse complex, but within the buffer zone during the second trial. So they're acknowledging that the court has control over the courthouse grounds. Grounds. The court has control over courthouse grounds, but where is the extent of the court's authority when it gets into public areas, public streets, and then private property? What about then? But there are times when courts can impede on private property, and we're not going to go down a whole line of cases about that. There are times when governments can impede on private property, but we are not going there. Today, we do not have time for an entire year of 1L crammed into today's stream. They say plaintiffs reasonably fear that Judge Cannone will attempt to hold them in contempt. That's exactly what I think would happen. I think that is a appropriate response, that Judge Cannone will attempt to hold them in contempt if they engage in such demonstration or will otherwise attempt another unconstitutional act to suppress those who would criticize her publicly. Look, anyone who's tried to get the county to sign off on any modification to property that they own knows where. Emily, you're going to get into thoughts about how much government should regulate private property, and we don't need that tangent today. We don't need that tangent today, Emily. But sometimes all the restrictions are ridiculous, and it just seems like people are making work for themselves. I'm done now. If it's your land, where are the boundaries? I mean, I don't know. I'm going to stop. Okay. There's an example within my county of a country music star who was denied the ability to build a taller house than fit within Williamson County. And it said that houses must be 2 stories. This is a level of pettiness that doesn't make me mad because I'm not the neighbor to this house. You can only build 2 stories within the area of the county they were in. And so because it doesn't say how tall those stories should be, what they did was build exceedingly large ceilings for both stories. And this went back and forth with the county. The rules have now changed to define exactly what counts as a story, like what is 1 story or 2 stories, and how tall a bottom floor can be vis-a-vis how tall a top floor can be, and said, you know what, you didn't say how tall my stories had to be, and built like a rooftop area on top of the stories, which isn't technically a 3rd story. It is a rooftop area, and was just like, it doesn't say in the rules how tall each story has to be. So deuces. They since changed the regulations because there was nothing they could do about it. So it is, again, I am not a neighbor. I imagine that country star probably has this house on 15 or more acres. So there probably actually aren't neighbors that are inconvenienced by this other than the trees. But it was just okay, well, it doesn't say my 2nd story can't have 20-foot vaulted ceilings, does it? Petty. And I'm not mad at that level of petty. It's like, okay, well, define a story. And this is why lawyers try to over-define everything. No house can be over 2 stories tall. Okay. Define a story then. But I digress. Let's get back to this. This is why you have to define things. Let's see. Like me just being like, you mean I can't just like dig a hole and throw water in it? Come on now. It's annoying. I would like to just dig a hole and throw some water in it, but no. Emily, it sounds like you're personally afflicted by the county at the moment. Look, I get it when you live in more densely populated areas. I understand. There are lots of fights over things in more densely packed areas. But when you have more acreage, if you're not a nuisance, Emily, do you want to discuss nuisance law? Not today. But, we'll get there. We'll get there another day, and we'll talk about nuisance. It's an interesting area of law, and I find nuisance really fun in law school. It's one of those things. It's like, well, what if you want to be like an amateur DJ at 3 a.m. on your roof? Is that okay? What if you want to have chickens? What if you want to have goats? What if you want to make sriracha? And, what if you want to fly a drone? Like, is the space above your house all yours or not yours? What about the space below your house? Like, how far below your house is yours? We could go on forever. We're not going to, because then we'll never get through this. Plaintiffs wish to continue to demonstrate, including criticizing Judge Cannone, and they don't want to be held in contempt. I think that's a reasonable fear because contempt is how you would enforce this. You would be probably, I would imagine, given a warning like, hey, FYI, you're within the buffer zone, and this is the court order. And if you violate the court order, you can be held in contempt. Plaintiffs reasonably fear that the Norfolk County District Attorney's Office, under the control and direction of Defendant Morrissey, will seek their prosecution for violation of the order if they engage in such demonstration. Fair. As Dedham police officers took action to enforce the buffer zone order during the first trial, plaintiffs reasonably fear that the police department will arrest them for violation of the second prior restraint if they engage in such demonstration. I think that's a reasonable assumption. Chris Bowman, this is my whole life. Yes, it sounds like Emily is talking to her brain out loud. That yes, I am a verbal processor. Cause of action count 1, violation of the First Amendment to the U.S. Constitution, declaratory judgment, and injunctive relief. Remember, declaratory judgment is, hey, Your Honor, declare what shit we can and cannot do. I do declare it, Your Honor, declare it. And then the injunction is stop it. Declare it, stop it. That's the defendant's, Libby, that's the defendant's last name, who's in charge of the police department. Plaintiffs hereby repeat and reallege each of the above. The second prior restraint order is facially unconstitutional. It is a content-based regulation of protected speech. And they made this point. This, if you didn't watch the breakdown that the chat is talking about with regard to TikTok, which may again be gone on Saturday, we'll see what happens to TikTok over the weekend. If you watched my Supreme Court hearing on TikTok, I did a breakdown of the different levels of scrutiny with regard to free speech. And there was argument at the Supreme Court about whether this was content-based or non-content-based. And the Supremes were in the vicinity of, and when I read the order, were clearly stated, this is based on the app. It's not specifically talking about one type of content on TikTok. It's just the app and the algorithm. It's not one thing or the other. This, they pointed out, is content-based. You can celebrate the Bruins, but you can't talk about this case. And so you could probably, there's other trials going on. I would imagine someone could be in the buffer zone talking about a different case in the same courthouse and not be subjected to this order. So this order is very much specific to the type of speech being any speech about the Karen Reed case. It's not, you can't be on a bullhorn talking about Cheez-Its being superior to goldfish. You can do that out front of the courthouse if you want to. So it's not a buffer for everything. It's just a buffer for this. So the court is defining a type of content, and they pointed that out. Businesses in the area aren't restricted here. So they are saying it is a content-based regulation of protected speech. I don't think they're wrong on that. I think it is content-based. It's in a public forum that cannot withstand strict scrutiny. While the Supreme Court has upheld a statute regulating or relating to picketing or parading near courthouses, it has not approved a 200-foot buffer zone with an additional larger ill-defined area. It is over-inclusive, and that is the key to the argument. Over-inclusive. When you're looking at strict scrutiny, which we're talking about First Amendment, strict scrutiny applies. We are talking about what is content-based. They are arguing it's overbroad. It needs to be narrowly tailored, very narrowly tailored. They are saying it is over-inclusive. It includes speech in private businesses and homes in a traditional public fora. I mean, if homes are within the zone, then, we'll see. It is under-inclusive as it does not regulate other forms of speech directed at potential jurors. I mean, Could you be within this buffer zone and say other things to jurors? It seems like you could, as long as it's not about the Reed trial. So, yeah, if you wanted to be out there like trying to get people to go to a concert or something, you could do that with a bullhorn. Fair. The second prior restraint order purports to address noise and to minimize prospective jurors' exposure to viewpoints about the Reed case, but it's targeted solely to speech in the ambit of the Reed case when Judge Cannone and the Superior Court routinely conduct jury trials without such restrictions. Well, I mean, fair, but I imagine most trials don't garner people standing on the sidewalk because most trials just don't. Judge Cannone could have taken measures to reduce jurors' exposure to noise and public speech without imposing content-based restrictions. That's a fair argument. What else could you do? How else could you bring jurors in and out of the courthouse? Could you bus them directly to the back of the courthouse? Could you make sure that there's no enhanced noise in the area where the jury room is of anything? Could you restrict bullhorns in that area while the jury is there? We'll see. They're saying that the order is unconstitutionally vague. Plaintiffs cannot ascertain where they may not demonstrate, as the purported bounds are not bounds at all. Plaintiffs cannot ascertain exactly what speech is prohibited. It is unclear if they can wave political signs that say vote against E.A. Morrissey or Judge Cannone is corrupt. Because do those signs specifically go to the Reed case? Or are those just political speech and opinion? That's a fair point. The second prior restraint is unconstitutional prior restraint on speech. The second prior restraint, even calling it a prior restraint order, is advocacy. They're not just calling it Docket 630 or 530 or whatever it is. They have labeled it as a prior restraint order because it's advocacy. The second prior restraint order is unconstitutional as applied. Defendants have been purposely targeted people like plaintiffs who dislike Judge Cannone, and there is nothing that suggests they would threaten anyone siding with the prosecution or supporting Judge Cannone. I don't think anyone's arguing that there are threats there. I do think that the judge, well, maybe this is giving the judge too much credit, but I do think that the noise is a concern here. But I don't see anything that the judge has done to try to protect the jury from that. So of all this argument really sticks pretty close and true to the argument. There are only a few parts that I think are a bit of a reach. I would be shocked if there were any filing that doesn't have stuff that was a bit of a reach. I'd be really surprised. And it's kind of buried at the bottom. They say plaintiffs have been injured or reasonably fear imminent injury by those constitutional violations, and plaintiffs are entitled to relief. Therefore, plaintiffs are entitled to a declaration that the second prior restraint order is unconstitutional, and they are entitled to an injunction against all defendants prohibiting enforcement of the order. Count 2 is violation of the 14th Amendment, which is your procedural due process because they weren't heard. Defendants' conduct of issuing and enforcing the second prior restraint is unconstitutional and violates the due process rights. Prior to being deprived of their rights to speak freely and to assemble, plaintiffs were entitled to due process. There was no hearing, no opportunity to be heard, and there was no due process. My question on this is, did they attempt to intervene when the Commonwealth filed their motion in the second trial? That's my asterisk on this. They go on to say Judge Cannone's second prior restraint order was issued in the absence of statutory authority or inherent authority over persons not brought within her jurisdiction through process. The prior restraint was a usurpation of legislative and regulatory factors, not a judicial act, that the judge has no authority over what non-parties to a proceeding may do off courthouse property, let alone on private property or traditional public fora like sidewalks, like across the street. They say the Massachusetts Constitution does not empower justices with explicit or inherent authority to regulate private property. And the private property is a big issue. They say that there's no ordinance in the town of Dedham that empowers justices with explicit or inherent authority to regulate private property or traditional public fora. Plaintiffs have been injured or fear imminent injury, demand for a trial, prayer for relief is declare it's unconstitutional, enjoin them from enforcing it, and award them attorney's fees. So that is the lawsuit against Judge Cannone. I am sure there will be a response from the police departments and what have you. My questions remain: did they seek to intervene in the second trial and were denied? And will the federal court say this isn't ripe because you didn't seek to intervene and were denied that intervention? And we might still see the attempted intervention, like with a motion for reconsideration or a motion to be allowed to intervene from these plaintiffs. So I'm not surprised that we are seeing pushback on this buffer zone. It is specifically targeted at this case and people speaking about this case. So the arguments that this is a prior restraint on speech, it is. Whether it is a lawful prior restraint is what the question is. And it's clear in the law that, again, those circles, the court can regulate the courtroom, the court can regulate the hallways of the courthouse, and even the property of the courthouse. But as you get further out and as you get into private property, that might be quite a big overreach. But I also haven't seen the motion from the businesses that asked about the court interceding on behalf of the businesses. So I will be looking at that before we come back to talking about the Karen Reed case, because I'm interested to see what the businesses, because if the businesses are the private property and they say this was significantly disruptive to our businesses, it will be interesting to see how that gets balanced. But the overreach of the court trying to limit First Amendment behavior on private property and on public property that the court does not have authority over is a very interesting question. Law nerds, we're going to get to a few questions, and then I've got to bounce. We got weather we got to deal with up in here. So that's what we are going to do. Oh, Miguelina, I can do a better summary than that, I think. Let's try to summarize. Those were my thoughts. Let's try to do a summary, because that was just me thinking. It was not a good summary at all. Let's try to do a better summary. We went through the Emily, we're going to try to do a summary, and all you're doing is staring out the window going, this is the calm before the rest of the storm. That's not helpful at all. I went through the lawsuit against Judge Cannone, DA Morrissey, and others regarding the First Amendment rights of protesters outside the Karen Reed trial. The arguments being that the buffer zone is unconstitutional for numerous enumerated reasons. Yes, I just said numerous enumerated reasons. I stand by it. Because it is a prior restraint on speech, because it is protected speech, because it targets just the Karen Reed case. The buffer zone order from the court doesn't say there can't be anyone on bullhorns within the buffer zone. It says you can't be demonstrating about the Karen Reed case on sound enhancing devices. So there are some questions here, and this has been taken up to the federal court. I still question whether or not individuals sought to intervene with the order in the second trial. In their motion, they point out that they were denied the ability to intervene during the first trial when a buffer zone was established. They were silent on whether or not they sought to intervene during the second trial. And the federal court may say, well, you need to ask the court first. If the court denies it, then come and ask us for declaratory relief and for an injunction regarding this. But the court keeps saying to the jury, as jury selection is underway, that this will be a 6 to 8 week trial. So this may have time on an expedited basis to work its way through the federal court to determine whether or not the court's order regarding an expanded buffer zone and restrictions on what people may do, wear, and say in that buffer zone is unconstitutional. I'm going to be keeping an eye on it as it goes alongside, because when the court rules what happens in the courthouse, it's one thing. But when you expand that beyond courthouse property onto private property and other public property, that's when you get very well into the area of First Amendment law and under strict scrutiny whether or not that buffer zone order is narrowly tailored to address the valid government interest of protecting this jury trial, or is it not? So we will see if the court balances that before this trial is done. I'm interested to see it. Let's get to y'all's questions real quick, shall we? It's time for Q&A. It's time for Q&A. I love that we've gotten onto snackies. Ice Ice Baby, peach rings are so good. Sour ones are so good. Peach rings with tahini, amazing. And I also do love black licorice. Like Australian licorice, 10 out of 10. The really soft black licorice, oh my God, it's so good. It's so good. I do. I love it. I love it. I love it. I know not everybody does, but I do. But I do. I know. Chat. The chat is divided. I know. I'm not telling you you have to like black licorice. I like black licorice. I do. Yum. Look, I don't like cilantro. It tastes like soap to me. I'm one of those people, but I do love black licorice. I do. It's fine. Leah Lee said, finally time for a live stream. Yes, it is. Get Knit Faced said, wear my lawn art shirt to a jury summons, yes or no? I'm not going to tell you what to do at all. I mean, you can just say I'm a big fan of justice. It doesn't mean you're biased. It means you're a big fan of justice. I like it. I actually miss weather watching. Like Queen, I really enjoy the late spring weather that rolls in without the swirly air. It is the swirly air stuff that's a little frustrating and a little something you have to be a bit more mindful of. But I love a good summer lightning storm. We would travel to the Jersey Shore and like Ocean City and Virginia Beach and stuff as kids. My parents grew up East Coast before they moved to California. And those summer storms were unlike anything we had in California. And I absolutely loved them. But it was like lots of lightning, lots of thunder, really moist, humid air. And sometimes you would lose power. Sometimes you wouldn't. That I loved. But this is a little stressful, but it will pass in a few weeks and we will be back. Let's see. Miss Krista said, can buffer zone supporters be charged with witness intimidation? It's really hard to give a blanket answer because it's really behavior specific. I haven't seen anyone accused of doing anything that would fall into that realm. I've seen people hold up signs and voice their displeasure and support Karen Reed and some that come in and support John O'Keefe, but I've not seen anyone do anything targeted at witnesses specifically that I have seen, but all of that is very behavior specific. And I think it would have to go beyond just questioning. So we will see. PR Chick 24, hearkening back to my earlier story about the judge that didn't understand how peremptories worked. This is a good lesson for all lawyers everywhere. Sometimes, I meant to leave that up. Sometimes, I lost it. There we go. Sometimes you need to know the basic shit, and the basic shit is the hardest to find in the code. Like the fact that you get X number of peremptories per case is spelled out in the code. Like stick to the code. It's in the code. But when the judge is like, well, Ms. Baker, where is that in the code? I'm like, fuck, that's just the rule, Your Honor. Like what do you mean, where is it in the code? It's in the code. It's just, that's the rule. So I asked the judge if I could have a few minutes to go look for it because I was like, I don't fucking know where it is in the code. That's the rule. Like this rule is so much the rule that nobody ever questions the rule. Like everyone just knows it's the rule. Like what? It's like both sides have the right to make an opening statement. Well, where is that in the code? I don't know. What? Like, it's so obvious that not having the ability to put my finger on it was a huge problem. I was like, please don't swear this jury. The judge had taken away numerous of my peremptories. I was pissed. It was a defendant that was drunk driving while on probation for a third DUI. So this was getting to the point where it would bump them up into felony DUI. They also had older DUI. Like this defendant had, if I remember, 7 or 8 or more DUIs, but they time out after a period of time. And I'm like, you're on probation for DUI. You don't have a driver's license. And they were like at work. I'm like, you're in your work uniform. You are drinking. You are driving. You don't have a license. And you're on probation for DUI. What are we doing? So when you pass a juror, like accept them, you don't diminish your peremptories. If you use a peremptory, you diminish the peremptory. Like I used it and it's gone. If you don't use it, you keep them for later in the panel because this juror may be great, but if the defense kicks that juror, then another juror comes up and that juror may not be great. So we got down to one last juror who should have been kicked for cause. This juror was like, I don't like this police department. I think they arrest everybody for DUI. They've arrested my friends for DUI. And this police department, by the way, part of their DUI task force was keeping an eye on the Jack in the Box. The amount of DUIs I had because somebody went into the Jack in the Box parking lot or into the drive-thru to get their food, stopped, and then fell asleep in the drive-thru at the window because they were intoxicated was a occurrence like every weekend. So law enforcement would really just keep an eye on the Jack in the Box and just be like, drunk, because people were trying to get some food. Like, I get it, but you can't. So that ended up being a large part of it. But I digress. So this particular juror did not have a fondness for the local police department and felt particularly that this police department was overzealous in their DUI arrests. This juror should have been kicked for cause. This juror was clearly a juror that could not be fair given the nature of the case. This is a juror who would have been perfectly fair on a different type of case. But this juror also was giving me all of the stink eyes, because was just like, fuck you for this. And I'm like, this dude has all of the DUIs. And this is a strong DUI because they're like, have you been drinking? He's like, yeah. And had been drinking and was over the limit and didn't have a license and all the rest of it. And habitually drank and drove. So we get to our peremptories and I'm like, great, I've got like 4 peremptories left. That juror is not the right juror for this case. And the judge would not let me use my peremptories. He's like, nope. And I'm like, I have 4. And the defense attorney's like, she has 4. I'm like, I have 4. And the judge was like, no, you don't. And then this whole kerfuffle happened. And I'm like, Your Honor, can we just not swear the jury? Because once the jury's sworn, jeopardy attaches. I'm like, can we not swear the jury and give me 10 minutes. Give me 10 minutes and I'll get you an answer. Give me 10 minutes and I will get you an answer. But I still have peremptories. And I still have peremptories. This juror can't be fair in this case. They should have been kicked for cause. He wouldn't kick them for cause. Fine. I still have peremptories. Great. We were not allowed to break. The court insisted on swearing the panel. I'm like, you can't swear the panel. You can't swear the panel. You can't swear this panel. Give me 10 minutes. Not a fucking chance. Swore the panel, swore that jury, swore that juror who was just like, the site judge and my supervisor and the defense, the PD supervisor all got involved. And in all getting involved, the public defender's office was like, shit. We don't want you to do this to us. So we need this judge to know. My office was like, you can't do this. And the site judge was like, what in the ever-loving fuck is even happening? And I'm new. And I'm like, it's in the code somewhere. Just give me 10 minutes and I'll find it. But no time was had. All of the bosses were concerned by this because this is going to go badly, not just in this trial, but in other trials. And then the defense would have to appeal. And that's a huge pain in the ass for the public defender's office. I can't appeal. I'm kind of stuck with where we're at. The jury was sworn, we're stuck. If it was the defense could ask for a mistrial. I can't ask for I could ask for a mistrial, but if I ask for a mistrial, then there's no retrial. It's just done. So I'm stuck. Just stuck. I Love Pie says, how does someone like that become a judge? This was a political appointment. There are a lot of great judges. There are a lot of great judges. There are a lot of great judges that are appointed. This judge hadn't done a trial. And there are times judges don't know. Good judges will pause to find out the answer instead of like vibes. I was so mad. I was so mad. How is it legal? Because it's the judge and I was the prosecution. So there's nothing I can do. So is it legal? Yes, it's the judge. What's the response? Appeal. I can't appeal. And I can't ask for a mistrial because jeopardy is attached. I'm just stuck. And there are times that happens. There are times you, as the government, are stuck. And the odds are generally the government has the ability to choose to bring a case, choose not to bring a case. There's lots of options you have. In this situation, stuck. I have told this story before. We've talked about this. Am I still bothered? Yes. Because in my brain, I'm sitting here looking at this defendant and I'm like, if you did not learn that drinking and driving is dangerous in your first, second, third, fourth, fifth, sixth, whatever DUI, we're going to get to the point where someone is hurt and or killed. And I prosecuted a lot of DUI related homicides in my career. DUI is unpredictable. It is unsafe. And most people, and in misdemeanor court, you see a lot of DUIs. A lot of people come in and are terrified. They come in on a first DUI and are shook. Don't want to drink again. Don't want to drive again. You can see it. They're just like, it scared the shit out of them. And they're like, this will never happen again. Fair. They are thankful they didn't hurt themselves or someone else. They are contrite. They are terrified. Different. When you have DUIs stacking up end over a period of 15, 20 years, it is a time bomb, in my opinion. So that's where I'm sitting at. And I'm frustrated because there's this one juror who fucking mad dogged me this entire trial. And I knew, and she knew, and we both knew. I knew exactly what it was. I knew what it was. She knew what it was. This whole trial. And you want to know what happened on that jury? Y'all know at this point. Y'all know at that point. Y'all know at this point. 11-1 hung jury. 100% 11-1 hung jury. This juror refused to deliberate, would not participate, and when they walked out, this juror sat there like this and was like, what are you going to do about it? Like, what are you going to do about it? What are you going to do about it? Nothing. Nothing. There's nothing you can do about it except do a retrial. So that was my very first hung jury. And as the jurors were being excused and the juror walked out, literally looked at me and went, I was like, that's excessive. Like, I'm aware, you're aware, we're aware. We all know. And I just looked at the judge. I was so mad. And I'm just like, Your Honor, are we all on the same page when we do this retrial now? Because this is great. This trial took us 6 days of court time and of jurors' time. You burned peremptories by not following the law, and now we need to do it all over again. Great. Everyone's thrilled. What happened to the judge? Nothing. The judge was relatively new. The judge, I think, understood how peremptories worked a lot better and understood why I was so mad. This judge and I did not have the best working relationship. I was collegial, but this was not my favorite court to be in. And I would sit there and just be like, because I was not always chill, I'm sure my energy in that court was like when you tell your kid not to do something and they do it and they're like, oh shit, what you said happened was going to happen. And then you're just like, Shocking. Shocking that this is the exact fucking result that I expected. Weird. That was my energy. That was my energy with that judge. Every now and then I'll still have friends call me up and share stories with that same judge because they know that I will always commiserate. I'll always be like, So no, I'm frustrated. Did I get to do the second trial? I did not get to do the second trial because the defendant, to the best of my memory, bench warranted, meaning didn't come to court a number of times. And then I got transferred. One of my colleagues did the retrial and convicted them. I have not checked to see if they ended up with future DUIs. Look, I was very cognizant of harm down the road. There were some cases that it's like, this person's not going to cause harm down the road. This person's not going to cause harm down the road. You look at a lot of cases and you're like, you're not, stop it. My supervisor at a different courthouse had the one of the bosses from Fish and Game in their office to yell about myself and another DA friend of mine. And the Fish and Game at this particular courthouse, and I worked with Fish and Game at a number of different courthouses. The Fish and Game at this courthouse were like, these attorneys are not taking our Fish and Game violations seriously enough. Right. Look, man, I'm not going to get real fluffed about like one dude grabbing one lobster out of season. Like, I know you're not supposed to, but at the last courthouse I was at, the Fish and Game violations we were prosecuting were restaurants sending ships out to like hatching grounds to poach lobster. That I'm a little upset by. I get it. But when you've got like somebody grabbing dinner, they're grabbing like a lobster. What, you want me to find them? How much more than they would pay for the lobster if they went to the store? Like, no. No. We're doing infractions. We're not doing it. Because the people who we should be spending our energy on are the restaurants poaching at the protected hatching grounds. There was a whole sting operation in one of the courthouses I worked with because the restaurants were poaching, and they did bait lobsters that were surreptitiously marked lobsters, so you could prove who was poaching the lobsters. That I can get behind. I can get behind it. But somebody grabbing a lobster, stop it. Just stop. So Fish and Game was big mad at us because we didn't take the solo cases that seriously. There were times they're like, but we boarded this person's houseboat and they didn't leave a tag on the fish. I'm like, look, I get it. Like, I get it. But also, they were almost done cooking. I don't know. They're almost done cooking the fish that they caught. Are we they're supposed to still have a tag of scale? Okay. Sure. I get that you're mad. Can we just give them a warning? And like, if they consistently do it, it's a problem, because this is not a problem. Now, the poaching stuff, mad about. Got it. The somebody getting themselves some food that they're going to eat. Okay. So Fish and Game was not appreciative that we didn't take everything really, really seriously. But in misdemeanor court, you have a level of seriousness, and yeah, it's like perspective. Perspective is needed for criminal prosecution and criminal defense. You need perspective. Is this person going to cause future harm, and will this case help derail that course so that they do not cause future harm to themselves or others? Or not? It's generally a good starting point. And that's, I think, maybe one of the things that frustrates me about the Karen Reed case, because well, of all the things, the over prosecution is one of the stunning ones, but there's a lot. All right. So with all of that, Aya says, we are not in old England and the lobster is not the king's deer. I mean, it's just, I'm not, again, poaching lobster out of breeding grounds with fishing boats so that you can charge a bunch of people more and you're depleting the lobster population, problem. A guy grabbing a lobster to eat, less of a problem. Perspective. But Fish and Game was not happy with us. And my bosses were like, there's days as a boss, I don't know how you keep a straight face. And the bosses were just like, Fish and Game is displeased with your level of enthusiasm for the prosecution of the lobster cases. And I'm like, yeah, they probably are. That's probably right. I got along with a lot of the Fish and Game folks. There were a few that we didn't. But that's the job. Look, man, warning. Give people a warning. And then if they become a habitual offender, then we'll talk about it. But I don't think they're running some like bootleg lobster ring out of their garage with one lobster. I'm not worried about it. But we did have prosecutions of people doing like garage dentistry. Somehow those cases always came to me. And the garage dentistry stuff, I was always like, what are you? What? Like you are going to harm someone doing garage dentistry. Lobster? Fine. Garage dentistry, I'm more concerned about. Like, let's not do unlicensed dentistry. That terrifies me a bit. It's more common than one would think. Yeah, garage dentistry, it scared me. Again, harm. Levels of harm. For those of you asking who would go to a garage dentist, go on TikTok and look at all of the issues going on with people who are not dentists doing unlicensed like veneers, like just grounding down on people's teeth and like just like super gluing on veneers. It's concerning. It's concerning. And there's a lot of the veneer technicians on TikTok. It's scary because it's scary stuff. But the veneers are aesthetic. It's just it's a bad idea. Was it a child Kathy Hilton? Nope, not a child Kathy Hilton, but yes. Not a child Kathy Hilton. So with that, Law Nerds, I think we did a lot of questions. Rolling along, I agree. The only unlicensed dentist I want is Kathy Hilton. I think it's fair. Rolling along, I understand that it can be a slippery slope. It's where I was prosecuting, the folks that were coming in with the lobsters weren't going to pay the fine. Those things were going to escalate, and it on the scale of things we had to deal with, it was not on the scale for me. These were not habitual offenders. I was not worried about it. All right. We have got to wrap up. I'm going to do a couple more questions, and then we got derailed on story time, and I got to go check in with the kiddos. And the weather is getting spicier. Kim, I Love Labrador says, girl, chat has me wanting to protest snacks in the buffer zone. I don't think they could stop you. I don't think they could stop you from protesting snacks. And just be like, bring Alessi's lunch. What's in the cooler? Turkey versus ham. I don't think they could stop you. So Celeste said black licorice ice cream. Yum. I even named my black paw nerd licorice. I love that. I've never had black licorice ice cream. That sounds amazing. I'm here for it. Thank you, EDB, for the tangents. I'm curious, can the judge approach the protesters outside and talk with them? That would probably cause problems. I would advise against it. What would stop the judge from doing that? I would have to look at the Code of Judicial Ethics in Massachusetts. I think it would be ill-advised, and it would potentially escalate things. So I think it would potentially be a problem. But what would be the rule that would stop the judge from doing that? I would have to look at the judicial ethics. But the most obvious answer is these are now parties in a lawsuit. And so the judge would be speaking to potentially speaking to the plaintiffs if the judge doesn't know everyone by face. The judge is being sued by Jason, Allison, Lisa, and Samantha. So that could cause a problem if the judge doesn't know who they are and went outside to talk to somebody. You could step on then talking to represented parties in a lawsuit that you are being sued in. That would be the most practical answer. Erica said, but Emily, did the judge bring in the dancing lobsters for fishing game? No, fishing game had, that particular group of fishing game had no chill. More experienced fishing game, the people that they saw all the time, they're like, stop it, you know. The people who were first time, they're like, we're giving you a heads up, don't do this again. They didn't bring everyone in. It's sometimes the younger agents that don't have that discretion. And sometimes it is your job to bring the discretion to the table. So Rolling Along says whether cilantro tastes like soap or not depends on genetics. I know, I learned that in one of the genetic tests that I did. Joe Jersey, I saw that Wonderland Pier in Ocean City was closed for good after last summer. I saw that. I was sad. I was sad. Dolly said, when you yeet StreamYard, play the AOL goodbye. It's a great idea. It would be like, goodbye. We will keep you posted on our new streaming software when we roll it out. We will probably do some extra members only lives to roll it out so that we can test it with you guys and not test it during a trial stream. I am going to leave you with, if you have not downloaded the Law Nerd app, get the Law Nerd app. You will need the Law Nerd app to stay in the loop on trials. Trial days are long. Sometimes they're unpredictable. I will keep you in the loop. Make sure you've got your notifications set to where you want them to be so that you get the heads up when I'm going live and when we have heads up on trial. A number of you said that they were done with court for the day. Oh yeah, no. Storms are coming as I switched over to look at the weather post. So I'm going to get going, but that's a lot of hail. I'm going to check on real quick the end of the day. Day 3, this is from Ted Daniel on the Bird app, said day 3 of jury selection for the Karen Reed trial is done. Clerk tells 10 of the 16 seats have been filled, 5 men, 5 women. So it looks like the court is looking for 16, not 18. They have 10. They could be done with jury selection if they get enough jurors to bring in a new veneer tomorrow, Monday. So 10 jurors is a lot. And jury selection is going much faster. See, they gave it plenty of room. They planned in advance. They were prepared for long jury selection. And then it was just like, we might be in trial next week. We've got lots to cover in Koberger, and we will balance that coverage together, but trial coverage is going to take priority. We will save other hearings and cover them. The hearings in Koberger will, again, the jury selection doesn't start till late August. So if that's what we need to bump, we will, but we will see. All right. Will they run through Easter? Yes, they will, but I don't know if they will have off either Good Friday or Easter Monday. I don't know what Massachusetts will do. They might have off one of those days. They might not, but trial's gonna start rolling here. So we'll see what happens. But if they can't get a veneer, if it could take them a couple days to get 6 more, it could take them 1 day. We just don't know. We'll see. I'm surprised at how quickly jury selection is going. Let's see how we're going forward. Hannah says Massachusetts public schools have off Good Friday. If the schools have off, the courts may have off, but the courts also may give off, if people's kids are going to be out, they may give the jury the day off if kids are out of school. So it wouldn't surprise me if Massachusetts had a state court holiday for Good Friday. That wouldn't surprise me. So aren't they both federal holidays? Not federal, possibly state, but that's state by state. So we'll see. It will just depend. But I don't remember from last trial if they were or if they weren't, because they were in jury selection. So we will see. PMA asked, do we have a federal decision on count 1 and 3? We do. The federal court affirmed the denials. I covered it on the Emily Show on Monday. So the federal court has ruled, and they are not stepping in to intercede. The Emily Show podcast lives on all your favorite podcasting apps and on the Quick Bits channel. So if you have the Law and Order app, you will just get it on Mondays. If you don't, hop over to the Quick Bits channel. It's over there. It's the Monday episode, so it's there. Pam, you're welcome. Yeah, there's no more roadblocks to this trial going forward. The court may want to have a day in between to hammer out some of the last things. The Commonwealth kicked up a fuss about the ARCA witnesses and is continuing to ask the court about the ARCA witnesses. They may want a voir dire day. They may ask for that if there's room in the schedule. So we might see some of that. Brentwood Chick said Nashville severe weather is going live on YouTube. That means it is time for me. It is time for me to get moving. Hannah asked a great question. Hannah said, do all judges have to have been lawyers previously, even appointed ones? In the US, they do. And generally, you have to have been a lawyer at a minimum 10 years. But that can depend on state. You have to be in good standing. You have to be a practicing attorney. Though I've seen attorneys get elected. Oh, there's the notifications. My Stormwatch Plus is going nuts. So I have seen lawyers run for elected judge that had been non-practicing. It's never good. I'm very tempted to just like give commentary on Ryan's commentary and just watch the weather come in with you, but I'm not going to. But if you are, I've seen elected judges who were non-practicing run for judge and become judges. I don't know why you would want to do that. That would be incredibly stressful. It would be like asking to be an umpire when you don't know anything about baseball. Like, why would you want to make those calls? Why would you want to make those calls? I don't know. Like, I don't know. But you do have to be a lawyer in good standing, and there is generally a requirement for how long you've been practicing. All right, Law Nerds, I'm going to go. Dream YouTube Inception. Okay, give me 30 seconds. Give me 30 seconds. Give me 30 seconds, and then we're gonna go. Let's see. Also, it's hard for me to watch Ryan Hall y'all live without. I really don't want to talk more specifically about where I live.
Essentially,
but
in the future,
hold on.
We will
switch tabs. Let's see.
That'll be 100, right?
I love how Ryan
something
runs
like
his
yesterday
channel.
ever happens again, the weather intensity score will be a 100.
Yesterday was bananas, Ryan.
No warnings at all is 0.
Hated it.
Does that make
Hated
sense?
it.
I think that's an easier way to quantify it.
There's where we live.
Especially since that was,
also, when I moved here, I still fight with people. I can't. Lebanon is hard for me. Lebanon is hard for me. If y'all don't know, Dr. B hasn't made it home yet. I reminded him earlier. I can only do so much. Yesterday was crazy. But if you guys don't watch Ryan Hall, I love what he and his channel do. They also have a 501c3 charity to help impacted areas. And so it's fantastic. I love the T-Dot cameras. And I love that I know where these are. I don't love when Ryan Hall's talking about where I live.
Potentially the third
Lebanon.
most
I don't know.
active day.
Yesterday was insane.
In like 40 years.
Hated it. Tired. I'm tired. You're right, Ryan. It was the worst. Strong tornadoes possible from Northeast Texas to Middle Tennessee tonight. Y'all, I'm going to go. The outside has gotten
Brad Arnold
swirly,
is in Lyon, Mississippi.
but I'm going to be watching
storm there that he's watching.
I'm going to be watching Ryan Hall, y'all. I'll probably be in the chat. You'll see me over there. There are many great weather channels. Go watch them. The fact that Nashville severe weather is also live means that this storm's coming right through our area. So I'm going to go. Law Nerds, it's great to see you. I'll keep you updated in the app, but I don't even have to. We've got 10 jurors seated in the Karen Reed case. The jury selection is going much faster than I expected. So stay tuned to the Law Nerd app because we are going to be in trial sooner than I expected. All right, y'all, don't worry. I will update you tomorrow. Where we live, hail and wind are the biggest issues, and we will be all good. So all of you expecting weather, stay safe. I appreciate you. Law Nerds, you're the best. And you know, it's hard for me to sign off because I have so much fun sitting here chatting with y'all, but I should be a responsible human and go be a responsible weather human. I'll see you guys soon. We're going to be in trial real quick. So buckle up, get your snackies over the weekend. Go snacky shopping. I'm going to want to know what snackies you guys have. On Tuesday, I'm going to be asking you about your snacks. Get your trial snacks ready, y'all, because it's going to be 6 to 8 weeks of trial, probably starting next week, given the way they're going. See you guys soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.